So Ms. Wood, we'll get on the record in a minute. Are you willing to waive Mr. Terry's presence for some of our administrative discussion?
Absolutely.
Great. Did it sound like he was on a train?
It did. It sounded like there was like moving.
Did it sound like the train was moving this way or like to Miami? Okay. We had a trial once. Bruce Harvey represented this guy, and he was for some reason out on bond. It was a murder trial. And this gentleman showed up on time for court every day until the last day of court. He had an ankle monitor. Last day of court, it was closing arguments, and so he had heard all the evidence and how that went. And we got a call from the monitoring company, or I think Ms. Nelson called the monitoring company. He said, the ankle monitor is southbound on 75. Oh, the ankle monitor just got cut. That was it. And the jury found him guilty. And the way the law works is that if you abscond in the middle of a trial and you're found guilty, I don't remember the name of the legal concept, but the word forfeiture is in it. But you have no appeal rights. You waive your appeal. And so Bruce Harvey, we get a chance. We like, this case law is very, very clear that if you become a fugitive in the middle of your trial and you're found guilty, it's as if you pled. So
did they find him?
Yes, but many months later, the fugitive team was looking on this phone, on that, and he was in Alabama, in either Montgomery or Birmingham.
I'm like, why don't they go to Mexico?
Exactly. It was not a profound location. So he got like a bonus 18 months, 2 years of being at liberty. Then he got life.
Yikes.
But he killed his girlfriend. That's what the jury said. Yep. All right, you let us know when you're ready. Okay, let's get on the record in State versus Terry. We have for the state, Ms. Smith and? Oh, you used to be at the public defender's office. Welcome to the district attorney's office. How long have you been with the DA's office? Okay, where have you been hiding out? Okay. Gowdy. And we have Ms. Wood and Ms. Rios for Mr. Terry. What we don't have is Mr. Terry. Ms. Wood has relayed to me that Mr. Terry is doing his best to get here, that his ride fell through, and so he's on the train now, which I take to mean MARTA, and his forecast is that he'll be here 9:30-ish. Ms. Wood, my understanding is that you are willing to waive Mr. Terry's presence, not for jury selection, but for talking about some of the preliminaries, like concerns about voir dire, the state's witness list. You've got a motion to reveal the deal. I figure we could work through all that while we are waiting for Mr. Terry.
That's correct.
Okay, so you're waiving his presence for that. Does it make sense to order the jurors up so they are heading this direction? You feel sufficiently confident that Mr. Terry was heading this way?
Yes.
Okay. Ms. Nelson, if you could please let jury services know we're ready for our jurors. All right. We will talk about voir dire in a second, but I'm going to start with the motion to reveal the deal. Ms. Wood filed that a couple weeks ago. And in the motion, Ms. Smith, Ms. Wood has sniffed out that perhaps the state has promised a witness, to potentially include a codefendant, some benefit in life in exchange for truthful testimony. But I'll let you articulate more since you stood up.
Your Honor, I don't know. It might be a moot motion at this point. I know there was a plea yesterday. I know we withheld sentencing. So I'm not sure.
It's not moot because it could well be that there is an understanding that if you do testify, then we're going to dismiss a count or this or that. I'm not saying any of that exists, but you're entitled to hear from the state if there is any representation that the state has made to this witness, whoever the witness may be, of potential leniency, because then you are free to use that in cross-examination of that witness. So the fact that the sentencing didn't happen yet doesn't mean there isn't an understanding of how sentencing might go. Well, there's not a way to forecast that, but at least the posture the state will take at sentencing.
Understood, Judge.
But if you don't want to know that, I won't press the state for it.
No, I do want to know it. I have done my fair share of research on the Codefendant situation. I am curious to know. I am planning to dig into that on cross-examination. I do know what his record looks like compared to my client's record. I did watch the plea yesterday, so I do know what the plea was to, and I know that Mr. Tevis and Ms. Smith both said there was no deal made, and Ms. Smith was very kind and sent me a synopsis of their discussions over the weekend. So that's why I was saying I don't know.
There may be nothing more.
Correct.
Okay. Well, let me just, go ahead.
One more thing, Judge. There was an amended witness list that came out last night that has a new person on it. I am curious to know if there was a deal in place, but that person was never charged to begin with, so I don't know if there was a deal to be made.
Okay. Well, let's start with that, and then I have a few questions for Ms. Smith. The witness list I have, and I made a copy for Ms. Rivers, was from the 17th. And so that may not have this last minute witness?
Yes, I've updated it since I e-filed it yesterday, the pending witness list.
Okay, I don't need to print it out if it's only one name. What's the additional name?
That name is Asia Lynch.
Asia?
Asia.
Like the continent?
Yes, last name Lynch, Lynch.
All right. And did you provide date of birth or contact information or something? You did?
Yes, I provided the date of birth and contact information.
Okay, so your witness list now has 10 names on it.
Well, when I admitted it, I took off some names. So right now we only have 7 names, and I can go down that list. So
Okay.
you can have the ones that were no longer called.
Why don't you just tell me who I should cross off from the March 17th list?
Number 2 and number 3, I think that's Officer.
Lopez is off
Mm-hmm.
and Officer Gash.
Yes, that's correct. I also took off the confidential information.
Oh,
I don't know what number that person is, but.
okay. It was intriguing to have that there.
Okay.
Okay, so no Lopez, no Gash, no CI.
Correct,
Okay, but yes to Ms. Lynch.
that's correct.
All right. Ms. Wood, are you asking for any relief in connection with Ms. Lynch? Have her show up early so you can meet with her, or anything you want to get on the record concerning Ms. Lynch?
Sure.
Okay. Then we've got a witness list, and I will get a copy to Ms. Rivers in a second. Ms. Smith, concerning the motion to reveal the deal, is the only witness that you might call who would be even potentially in a posture of getting any benefit from the state, Mr. Adams?
Yeah.
So Ms. Lynch hasn't been promised anything or isn't not going to be charged because she's coming in?
No, Your Honor. And
Okay.
to be clear, to respond to that motion to reveal the deal, the state has not provided any promises of any agreements or lower sentence or anything in this case regarding Mr. Wingfoot Adams.
Okay.
Yeah, I will proffer with him, which I shared those notes with Ms. Wood, but regarding any promises for any sentencing or anything like that, the state has not promised Mr. Adams anything.
Okay, which is what you said yesterday, and what you've told Ms. Wood. And we just need to confirm that in connection with the motion. So good to know. If something changes, you have an ongoing obligation to let Ms. Wood know that, you know what, he asked for this benefit, turn himself in 6 months late, and we've agreed to do that.
Okay.
I mean, before his testimony, not something that happens down the road.
Wood, thank you.
Okay, you're welcome. Ms. Wood, that was the only motion I saw in the docket. Any other pretrial matters we need to work through? Oh, I have a question for you. So the indictment, Mr. Terry is not charged in every count. There's a gun count. Mr. Terry's not charged in that. There's a reckless conduct count. He's not charged in that. And I thought of reasons why you'd want those front and center in the indictment, but also reasons why you wouldn't want jurors to be confused. And so you hadn't moved, but I don't want us to, when I read the indictment, not today to the potential jurors, but Monday to the actual jurors, I really only read the counts that include Mr. Terry, but I'd let them know there are other counts because there's a co-defendant. None of that's going to be secret. But I wanted to make sure you didn't have any concerns about how we handle that.
Judge, I think I want that on here.
Okay, that makes sense. And by them, you mean the counts, I mean, one count, both Terry and Adams are involved in. There are 2 Adams only counts, the gun and the child. And you are not objecting to effectively the whole indictment being what the jury gets to see, hear, and hold in the jury room.
Yes, Judge.
Okay. Ms. Smith, any issue with that?
Yes, Your Honor, the state would object. We would just like for the indictment or the charges that the defendant in this case is charged with to be read to the jury.
So I would read to the jury only the the 2 counts for Mr. Terry. What I was sharing with Ms. Wood is that absent a motion that I grant, the indictment as a whole would go back with the jury. I just needed to make sure there wasn't a defense concern about that. It sounds like there's a state concern, or you just want to make sure when I read the indictment, which I won't today. Today, I'm simply going to say Mr. Terry is charged with trafficking in methamphetamine and possession of drug-related items. That's what they're going to hear today.
I was referring to the form, just when you read it to the jury.
Okay, got it. Then we're aligned on that. Other than that, I forgot to print it out, so I'll get the indictment in a minute. We have, how long do you think the state's presentation will take?
Maybe a day.
Okay. Monday, we've got all day. No hard stop there. Tuesday, we have to stop a little bit before 4, but it sounds like you'd be done before then with your presentation. Wednesday is a drug court day, so we wouldn't start until noon, 12:30. But it sounds like that might just impact deliberations if they're still going. Ms. Wood, do you have witnesses beyond your client and the state's witness list? Okay. So any reason why the trial would take more than a day, day and a half? Okay. I'll qualify the jurors through Wednesday. That should be plenty of time. And we will see how that goes. Okay. That gets us to voir dire. Ms. Smith, were there any questions, any changes you want to make to the general voir dire?
No.
Was that good?
Yes.
Okay. Ms. Wood, anything?
The next to last question about have you ever worked with or volunteered with recovering addicts? I don't know. I guess we can leave it like that and I can explore.
We can reword it. I wanted to, there wasn't any other question. You both had some questions about drug use and this and that. And this is not a case that involves a crime. It's not our usual one where, have you worked with victims of domestic violence, which would have been very germane in Mr. Johnson's case, or someone been shot before. There's not a question about have you been the victim of a crime, because it's not a victimless crime, but that's the sort of generic term for it. But lawyers often want to be able to suss out, well, I actually feel real strongly about methamphetamine because my younger brother OD'd on it. And this question really doesn't get to that, but at least it's getting into the space of, well, yeah, I do work with recovering addicts because it was something important in my life. I really never got to know my father because he was an addict, or whatever the person's situation is. So maybe we replace it with, have any of you had your life impacted by someone in active addiction, or because you're entitled to explore that. You may not want to. You may not want to know that that landline is out there, but I suspect you do. And I didn't want to foreclose that area.
Yes, if we could just tweak it, because I like where your head's at, Your Honor.
Thanks.
Because I don't want people to be precluded, if people are affected by drug addiction in their personal life, but they don't answer the question because they think it's only like a work,
Right.
Actually working with addiction affected people. So
maybe it's 2 questions. Maybe it's the one that's in there, and just before it, the question is, it's one of these: have you or someone close to you? Have you or has someone close to you been seriously affected by drug addiction? You all right with that, Ms. Smith?
I'm okay with that as an addition.
Just okay? I mean, it'll fly though?
That's fine. Keep the original question.
Yes, ma'am. And just before it will be what I just said.
No problem.
All right. My last question for you all, and then I'll go print out the indictment. Ms. Wood, you've been very flexible about this cell phone extraction and getting the information. And I believe Ms. Smith relayed to all of us that the state doesn't plan on using anything that they may have bumped into in any of the extractions. Do you feel comfortable going forward with the amount of time that you've been able to work with extractions, which is not a ton of time, which is why I'm asking?
just for the record, Judge, I was never able to actually get into the extractions.
Okay.
But I feel comfortable knowing that the state is saying they're not going to use any of it. Of course, if it comes up in trial, I will let everyone know.
Sure.
But As of right now, I'm good.
Okay, it's not the case that insofar as you want to even comment on this, that Mr. Terry is saying, if you could just get into my phone, you'll see that I was there to get wings, and that was it. I just was getting wings. That you aren't trying to get in there because there's something you know you want to find and you're having technical issues. Okay, great. Let me go get the indictment, and maybe someone will show up. Jurors or client. All right, we need to get a couple more things on the record while we're waiting for one juror. So we're back on the record in State versus Terry. Mr. Terry has joined us. Mr. Terry, good morning. So you understand, we are going to pick a jury today. Monday, we will start with opening statements, presentation of evidence, etc. You need to be here on time. If you are not here on time, I'm going to take away your bond until the trial is over because we need you here for trial. Coming late's not okay. I appreciate you. Your ride fell through, but you have been late almost every other time we've had court. And now we're gonna have, right now we have 51 people waiting on us. And you'll have 14 members of our community who will be here and you need to be here for them. So if you need to do 3 backup rides or spend the night in there's a hotel, Origin Hotel is right next to the courthouse. Whatever you need to do, walk, bike, be here before 9 o'clock on Monday morning, okay?
Yes.
Excellent.
We had got evicted last night, so I was.
Your life was totally upside down.
Yes.
Okay, I'm sorry to hear that. And those things, those don't happen all that often. Will you, over the weekend, have a place to be, or you're working through that?
I'll find somewhere now.
Okay, well, keep Ms. Wood posted. And I'm letting you know now, between the close of business today and Monday, you don't need to be here. Ms. Wood may need to meet with you and talk with you, but you don't need to come to court tomorrow. Monday, you need to be here by 9 o'clock. All right?
Yes.
All right. Deputy Gordon, if you would grab the indictment and get it to Ms. Smith. Ms. Smith, can we one more time get on the record what the state's offer is so Mr. Terry can say, yes, I want to do that, or no, thank you, and then we can get jurors in here.
Yes, Your Honor, the offer from the state is 15 years to serve for count 1, and just count 1, so 15 years to serve.
So then there's a misdemeanor as well.
That one is a 12 months to serve to work concurrent with count 1.
Okay, so the state's recommendation would be straight time, no probation, but 15 years, which are parolable? I didn't see a recidivist notice in the, okay. All right, so Mr. Terry, if you were to enter a plea today, the state would recommend 15 years to serve on your charges. Do you understand the state's recommendation? Is that something you're interested in pursuing?
No.
Okay, then we're in the right space at the right time because we have 51 potential jurors who are about to come in. Ms. Wood, do you waive any issues working off of a copy of the indictment?
Okay.
Okay, Ms. Smith is going to sign it. And then if you would indicate Mr. Terry's not guilty plea on that indictment, we'll be good to go. Mr. Terry, because you are for now on bond, if you need to take a break, use the restroom or whatnot, just let your attorneys know. We don't have to stop what we're doing. You can just step out and use the restroom. We will be taking breaks during the course of the day. But if in between those breaks you need to step out, just clear it with your lawyers. You still waiting on number 43? Yeah, they're sitting next to each other. That's hilarious. Did someone communicate that they know where 43 is? Okay, there shouldn't be a lot of confusion today because we're the only case. Okay. If not, we'll just skip 43. Great, please. Oh yeah, why don't you all spin around, and if you need to make the monitor lay flat, you can do that. Mr. Terry, you're going to want to face that way.
This one,
Yeah. You want to go in the front row, right there. Yes. Deputy Gordon says we do.
Okay.
Thank you. Oh, I'm not good with teams, sorry. Good morning, ladies and gentlemen. Morning. I'm Judge McBurney. Welcome to courtroom 8D. We are going to be selecting a jury today in a criminal case. That's why you all were summoned down to the 7th floor and then brought up here. It is the matter of the state of Georgia versus Julian Terry. I'm going to tell you a little bit about the allegations, and that's all they are, is allegations in a little bit. But I want to thank you for being here. There are lots of other places you could be, but today this is where you need to be because you were summoned, and we have a legal dispute between the state and Mr. Terry that we need members of our community to resolve. The state has accused Mr. Terry of a couple crimes. He's entered a plea of not guilty. That status of being not guilty rests with him unless and until the state can prove beyond a reasonable doubt that Mr. Terry committed one or both of the offenses charged. And what you will do as jurors, if you're selected to serve, will be to listen to the evidence and decide if that evidence is sufficient to convince you beyond a reasonable doubt that Mr. Terry did one or both of the things that are charged in the indictment. That's how the process works. And that's why we need you to make that decision at the end of the trial. The lawyers estimate that the trial will last about 2 days, maybe 2.5. We actually start on Monday. Today we're picking the jury. So if you're selected to serve, you'll be back here on Monday morning to begin receiving evidence. We may finish on Tuesday, but I need to make sure your schedule is clear through Wednesday, just in case. And there'll be an opportunity for you to let me know that next week doesn't work for you. Although I'll put some limitations on your expectations of what qualifies as a hardship to get you out of jury service. Today, again, all we're doing is picking a jury. It's a process that takes most of the day, especially the higher your number. We start by having some questions posed to all 51 of you. Then we break you into smaller groups so the lawyers can follow up. And each group, when it's completed, gets to leave for the day. And we start with number 1 and the first group first. So a higher number means you'll be here a little longer. Although while we're working with the individual groups, you don't need to be here in the courtroom. You can be out on a break. You can go get lunch, whatever you need to do. But for some of you, we'll be together through mid-afternoon as we work to get a jury that can be fair and impartial in this case. That is the touchstone. Is that we're looking for jurors who come in neutral. They don't know anything about the case. They don't know anyone involved with the case. And they're not bringing in some bias about the case that would make it difficult for you to decide the case on the evidence, as opposed to some preconceived notion you've got about whatever the situation is. I'm going to have the lawyers introduce themselves in just a moment. You've met Deputy Gordon. He is the deputy who got you in here and is my bailiff, and he will be here most of the day. He gets breaks, but for the most part, that'll be the person that you want to turn to if you're looking for a restroom, or you need to take a smoke break. That needs to be outside the building, or a vending machine or something like that. Turn to him. Ms. Rivers is the court reporter I get to work with. She is seated in front of me. She could give you good advice about where to go as well, but if someone is in court and talking, she's busy because she is making a record of whatever's being said, whether you're saying it or I am or the lawyers are. I have a few other staff members who may trickle in throughout the course of the day. They are also available to help you out if you have questions. Representing the state in the matter of State versus Terry are...
Good morning, my name is Olivia Smith. I'm the Assistant District Attorney here at the DA's office.
And good morning as well. My name is Ivory Gowdy. I'm also an Assistant District Attorney as well.
Thank you, counselors. And representing Mr. Terry.
Good morning. Thank you for being here. My name is Lacey Wood. It's my honor and privilege to represent Mr. Julian Terry. This is my trial partner, Ania Rios. Thanks for being here.
Thank you, Ms. Wood and Ms. Rios. Ladies and gentlemen, as I mentioned, the lawyers estimate that this trial should last a couple days, Monday and Tuesday of next week, maybe spilling into Wednesday a little bit. Mr. Terry is charged with trafficking in methamphetamine and possession of drug-related items. He is charged with those offenses in this indictment. This indictment is simply a charging document. It's in some ways like a formal traffic ticket. It's the way someone says, hey, I think this happened. It is proof of nothing. It's the way the state brings charges against someone. You get indicted. Mr. Terry sits before you, as I mentioned, with the presumption of innocence in his favor. And that presumption stays with him unless and until the state convinces each of you, if you're selected to serve as a juror, that Mr. Terry is guilty beyond a reasonable doubt of one or both of the offenses charged. And at no point during the trial would the burden shift. We wouldn't reach a point where I say, all right, Ms. Smith, that's enough. Ms. Wood, you better tell the jury something because we've heard a whole lot from the state. There is no burden on Mr. Terry at all. I expect his lawyers to be very active in his defense, but they do so because they believe that's in his best interest, not because there's any burden that Mr. Smith convince you of X or Y or Z. That burden is solely on the state. What we're going to do for the rest of the day is complete a process called voir dire. It's a French phrase that means see what they say. And it's an opportunity for the lawyers and for me to see what you all say in response to a whole bunch of questions. Questions that are not meant to pry, but are meant to allow us to learn a little bit more about you to make sure that, in fact, this is a case about which you can be fair and impartial. As an example, if this were a slip and fall case in a Kroger where the claim was that Mr. Terry was the plaintiff and he said, I slipped in the produce section and I broke my arm, and he's suing Kroger. If one of you worked for Kroger, probably the defense wouldn't want you on the jury because you might feel a certain way about your employer and you might know what a bad job they do in keeping the produce off the floor. But the only way the lawyers know that you work at Kroger is by having us ask you a few questions like, what do you do for a living? And if you were to say, I don't work at Kroger, but I work at Publix, they might have some follow-up questions. Well, do you work in the produce section? Have you ever been involved in doing the inspections to make sure that there's nothing that you could slip on the floor? So you might have some specialized knowledge that either the lawyers really, really want to have on the jury or they want to keep far, far from the jury. But we only learn that by asking you all questions. You must answer every question that applies to you. We might get into a space that for you is private and personal. And the way we handle that is that instead of not answering the question, you simply let me know that you want to talk about that in private. And we make sure that the other 50 jurors are not in the room while you tell us about whatever that situation may be. There are not many questions that ought to get into a space that you think is private and personal, but I'm not the arbiter of that. You let me know. You may not want to tell everyone else what you do for a living. So I want to speak about that in private because I'm an undercover agent. Okay. We'll still need to learn that, but we might talk about that with the other potential jurors not in the room. And as I mentioned, it goes in two phases. I will be asking all of you, all 51 of you, some questions in just a moment. And when we're done with that set of questions, then we're going to break you up into 3 groups of 17. The first 17 will stay here while the remaining 34 will have a break, and then we'll cycle through each of the 3 groups. Before I can ask you or the lawyers can ask you any questions, I need you to take what's called the voir dire oath. So if you could, with me, stand and raise your right hand. Do you swear or affirm that you shall give true and correct answers to all questions asked concerning your qualifications as jurors in the case of the state versus Julian Terry? Please say yes if you so swear or affirm. Does anyone not so swear or affirm? Okay, you are all officially potential jurors. So I have a couple dozen questions I'm going to be asking you, and the way you respond to these general questions is by doing what I'm doing right now. I'm holding my numbered card up high with the number facing forward and not upside down. So if the question applies to you, this is all you do. You hold your card up and I'll call the number out. You don't need to explain your answer at this time. I'll just say 52. And the lawyers are writing down all the numbers because in phase 2, when you're up in the jury box and they're following up, they're going to know that you raised your card to this question and they'll say, well, juror 52, tell us about X because you raised your card in response to that question. When I've called your number, please lower your card so I can see all the cards all the way to the back, with one exception. If the question is confusing to you and you're not quite sure, well, I don't know if I fit in this or not, Judge, so let me ask you this question, do not lower your card. Bless you. So if at the end of me calling out all the numbers, 52 still has his card up, I'll say, juror 52, what's your question? I'll say, Judge, your question was XYZ, and I'm not quite sure. And I'll say, no, that's not what we meant. So we will not include you. Or, yep, that's close enough. So I'm going to include you in this group, and the lawyers may ask you about that when they are doing their follow-up. All right, let me get my paperwork ready. First question, does anyone have trouble reading or understanding English? Raise your card if at this beginning point in the trial, before you have heard any evidence, you are not neutral, meaning you are already leaning to one side or the other. Yes. Raise your card if at this beginning point in the trial, before you have heard anything about the case, other than what the allegations are and the names of the lawyers and the defendant, you are not neutral, meaning you are already leaning to one side or the other. 41, 46. Do any of you have any 49? All right. Late decision there. 31. Do any of you have any moral, ethical, religious, or other philosophical basis for not serving as a juror? 22. As jurors, you will be the fact finders. You will decide what happened in this case, if anything happened at all, but you must apply the law to the facts that you find. The law would include, for example, the elements of the charges and burden of proof and things like that. I need to know, by you raising your card, if any of you believe that you would be unwilling to follow the law that I give you. At the end of the trial, I tell you what the law is that applies to this case, and you must apply that law to the facts as you find them. Is there anyone here who believes you would be unwilling to follow the law that you receive? 22. Did you put your card down before? Did you change your mind, or don't lower your card till I call the number? Law. 31. 39. And 41. And 2. Anyone here not yet 18 years old? Does anyone no longer live in Fulton County? You all did at one point. That's how you got the summons. Is anyone here not a U.S. citizen? Raise your card if you have been convicted of a felony. A felony is a crime that is punishable by a year or more in custody. It doesn't mean you ever went to jail, but if you have been convicted of a crime and your sentence was denominated in years rather than weeks or months, then that could be a felony, and we need to talk about it. Raise your card if you've ever served on a grand jury. A grand jury. This is a trial jury or a petit jury. A grand jury does something very different, and you would know if you'd been on one. Is anyone here a post-certified law enforcement officer? Do you know either of the assistant district attorneys who are trying this case, Ms. Smith and Ms. Gowdy? Do you know anyone else who works in the district attorney's office? Lawyers, investigators, support staff? Number 1. Do you know either of Mr. Terry's attorneys, Ms. Wood and Ms. Rios? Are any of you related to Mr. Terry or think you know or recognize Mr. Terry? Do any of you know anyone else in your group? Got 51, in theory, strangers, but in the end, we end up getting neighbors or this or that. Number 41, well, let me start beginning. All right, 18, you know 19. And 19, you've called technicals on 18. All right. 41, who do you know?
47.
47, do you know 41? All right, thank you. One other card went up. Did you stop knowing people? Nope, okay, 41 knows 47 and vice versa. All right. If you're selected to serve as a juror, you will be with us on a given day from about 9 to 5. We take regular breaks. There'll be a lunch break. You'll be in much more comfortable seats. But while you're in court and we're active, you will need to be focused on what's going on. Watching a witness, listening, there may be video, who knows what. You'll need to be able to absorb all that. And I share that with you because my question is whether any of you has a physical or medical condition that you think would make jury service problematic. Number 12, as I've now, 38, 24, and 49. As I've now mentioned several times, the lawyers estimate that the trial will take a couple days, but we're going to be safe and try to block out 3 days. So Monday through Wednesday of next week, although Wednesday, if we spill over into Wednesday, would be a half day. We'd start around noon instead of at 9 in the morning. I need to know, don't raise your cards yet because I have to talk for a little bit, if for any of you it would constitute what we call an undue burden or serious hardship to be here those 2.5 days. And here's what I mean by those terms. They are legally defined. The kinds of things that get people out of jury service, once they've made it this far, would be, number one, you have a prepaid personal vacation, not a work trip, but you're going to be able to show Deputy Gordon on your phone, here's my Delta ticket, or this is a hotel I've already paid for, and it's for a personal vacation that I'm taking in the middle of next week, because that's when it would be. The other is medical related. If you or someone you care for, your kid, your parent, your significant other, is having a non-elective medical procedure, so not teeth cleaning or going for an annual checkup, but a non-elective medical procedure on one of those 3 days, you need to go. If it's you need to be there for that other person. Those are the kinds of things that rise to the level of we ought not to interfere with that. Job, kids, life, video games, those aren't the kinds of things that will get you out of jury duty. I will listen to you, but I'm not authorized to excuse you because your job is a tough time of year, you're a tax accountant, or whatever it may be. So with those parameters, raise your card if you believe serving as a juror Monday, Tuesday, maybe half of Wednesday would be an undue burden or serious hardship. 7, 12, 19, 25, 28, 31, 34, 46, 48, and 49. 7, you kept your card up. Question?
I'm not.
Okay. Just wanted me to know you've got a hardship. I got it. Okay. I'm going to read to you all the names of potential witnesses in this case. And if you recognize one of those names, please raise your card and we'll work through whether it's the same John Doe who's going to be testifying as the John Doe that you know. From the South Fulton Police Department, Patrick Charles and Carl Mickens. From the GBI, Natasha Eklund. From another law enforcement person, McBurney Ascu. From the Fulton County DA's office, Amina Dickerson. And then a couple of, I'm gonna call them civilians, non-law enforcement, Wincliffe Adams and Asia Lynch. This case involves an alleged drug transaction from August 28th, 2024 at the Wing Depot at 3389 Roosevelt Highway in South Fulton. Anyone familiar with that incident? Not the location, that's the next question, but that incident. Anyone familiar with an alleged drug transaction on that date at that location? That location, the Wing Depot, is, as I said, on Roosevelt Highway. It's a shopping center on Roosevelt Highway, right where Buffington Road starts or finishes, depending on which way you're going. So it's a T intersection. And along one side of Roosevelt Highway is a little strip mall where that Wing Depot is. Does that strip mall, shopping center, is that a place with which you are familiar? 7, 39, 41, 44, and 47. The next few questions involve not just you, but potentially people close to you. And they're going to start with the phrase, have you or has someone close to you, whatever the question is. We're expanding it a little bit because sometimes something can happen to your brother or your girlfriend. And even though it didn't happen to you directly, it had a meaningful effect on you. And so be thinking about when you're answering the question, well, it didn't happen to me, but gosh, this happened to my best friend. I went to court with him and he was upset and I was upset. But again, the focus is if it is someone else, that it had an impact on you, because the lawyers are going to ask you a bunch of follow-up questions. And if your answer to all the questions is, I don't know, I just know it happened, then don't raise your card, because that's not something that impacted you. First one of these questions, have you or has someone close to you ever been accused of, arrested for, and or convicted of a crime? DUI through murder. So a kind of crime where that person might have been in handcuffs as a result of the arrest, if there was an arrest. Accused of, arrested for, convicted of a crime, DUI through murder, not a traffic violation. Raise your card. 4, 5, 6, 7, 11, 12, 14, 16, 17, 18, 19, 22, 23, 24, 26, 27, 35, 36, 41, 47, and 50. Have you or has someone close to you been accused of, arrested for, or convicted of a crime, DUI through murder? If it wasn't you who had that experience, that person's situation needs to have had an impact on you. So we're not interested in knowing that your cousin got arrested for something. It would be, and I feel strongly about it because he was guilty as heck. He was the wrong guy. I'm upset with the system. You can see what the lawyers would want to follow up on. So it would be the impact that situation had on you. All right. Have you or has someone close to you worked in law enforcement, police, parole, probation, state, federal, any kind of law enforcement? You or someone close to you worked in that field. Same caveat, if your uncle was a police officer and that's all you know, and your uncle didn't talk to you a lot about his job, and you've got thoughts about law enforcement because what your uncle told you, if you fall in that category, raise your card. But if you just know your uncle was a police officer, don't raise your card. 1, 2, 4, 5, 12, 14, 15, 18, 26, 32, 48, 47, 45, 12. Your card's still up. Do you have a question? Okay. Have you or has someone close to you had a memorable experience, good or bad, with law enforcement? And this is law enforcement in its official capacity, not, and I used to date a cop and it ended badly. Don't need to hear about that. But if you were pulled over for all the wrong reasons, your life was saved by police, bad experience, good experience, you or someone close to you have had a memorable experience, good or bad, with law enforcement, card up. 2, 4, 5, 6, 7, 8, 10, 12, 14, 16, 18, 22. It's almost all even numbers. 26, 31, 32, 36, 39, 41, 42, 45, 46, 47, 49, and 50. Raise your card if you or someone close to you have worked as a prosecutor or a criminal defense attorney or worked directly with one. So you or someone close to you worked as a prosecutor, defense attorney, or worked with them. 1, 8. Raise your card if you have 26. You or someone close to you worked with a prosecutor or a criminal defense attorney. Okay, 26 it is. Raise your card if you have any formal legal training. You went to law school, paralegal school, whether you practiced or not, you got formal legal training. 1, 21. Have you or has someone close to you been seriously impacted by drug addiction? You or someone close to you seriously impacted by drug addiction. Why don't you put your cards down? Raise your card if you or someone close to you has not been seriously impacted by drug addiction. Well, I think the lawyers are keyed on the other question, so you're getting good arm exercise. We're going to flip it back around. I thought it's a little more than like 60-40. Back to the first question. If you or someone close to you has been seriously impacted by drug addiction, put your cards back up, please. I'll just call all those numbers. 1, 2, 3, 4, 5, 7, 11, 12, 13, 14, 15, 16, 17, 18, 22, 24, 27, 28, 31, 32, 35, 39, 40, 41, 46, 47, 49, and 51. Have you ever worked with or volunteered with recovering addicts? Worked with or volunteered with some organization that supports recovering addicts? 24 and 42. Anyone need to change answers? You are only now remembering that you know where the Wing Depot is. Nope. Okay. Ladies and gentlemen, that completes part 1 of this process. In a few moments, 1 through 14 will be following Deputy Gordon's directions on how to fill up the jury box. And 15 through 17 will move up 1 row and sit over in the corner, sort of near Ms. Gowdy, in front of Ms. Gowdy. 18, raise your card, through 34. Where's 34? 18 through 34. I need you all back here at noon. It's 10:30 now. This is your lunch break, unless you want to eat lunch after you're released, because you'll probably be released around 1-ish, a little after 1. You don't have to leave, but you are free to not stay in the courtroom between now and noon. But you need to be back by noon, each one of you. We've got your info because you're here, and so I'll drag you back here, and it will mean you probably watch the trial from sitting out there and maybe the next 2 or 3 of my trials if you don't come back. 35 through 51, you're way in the back. You are our third group, and I need you all to be back by 1. That's a bigger break. You can go further away, but you need to be back by what time? 1. So group 2, you're back by noon or 12. And group 3, which is 35 through 51, you are back here by 1 o'clock. Feel free to go eat lunch, whatnot, but you all need to come back. And you don't have to leave. You're welcome to stay right here or just go right outside. You can go back to the 7th floor, the place with the red chairs and whatnot, if that's where you want to spread out. But if you're in here, you can't be using your phones. If you're going to do that, you need to be outside the courtroom. Any logistical questions? If you are number 18 or higher, do not take your card with you. Leave your card where it is. Deputy Gordon, do you want the higher numbers to leave first, or do you want 1 through 17 to do their snake? Got it. So if you are on what to me is the left side of the room, go out those doors. If you're on what to me is the right side of the room, go out those doors. But 1 through 17, don't go anywhere. Thank you. So we're not on the record, but I'd like to at least informally start talking about the motions. I don't think we have all our jurors yet. Rios got the mode in.
No.
Pardon? This just one. Great. Maybe Ms. Rivers is bringing that juror in. Okay, excellent. Anyway, we should at least have some basic discussion about some of the issues that arose over the weekend. And I'll, of course, hear from both sides. I'll give you my going in thoughts that I think Task Force Officer Ascu is going to be able to testify, but I'll be interested to hear the areas you think, Ms. Wood, you wouldn't be able to get into. Assuming the CI is not testifying, and we'll work through these assumptions, and the late disclosed materials from TFO Ascu are not coming in, so text messages, and I think there was some kind of video that the CI made. Assuming those aren't coming in, paragraph 1 of what Ascu is permitted to testify about pretty much allows, I think, both sides to ask her about anything. That paragraph is how the CI came to be involved in the operation that led to the arrest of the defendants. That would be from when did you start working with the CI, not how you recruited the CI. There's some techniques and policy things that the U.S. Attorney's Office has carved out, but I saw enumeration 1 as being broad enough that, one, the state would be able to lay out all that it needed to in terms of how the operation was set up and maybe what preceded it. And then it seemed like that would also give you very wide range to cross-examine TFO Ascu. So tell me what your concerns were about the limitations that you saw being imposed by the March 20 letter from AUSA Ben David.
Judge, so are we working under the assumption that the videos and the text message are not coming in?
Assume for our discussion right now, that's not my official ruling, but I'm previewing where I'm leaning based on what I've read.
Got it. So first of all, in all my years of practice, albeit only 8 years of practice, I've never in my life seen such. I recognize I do not practice in federal court. I understand.
Oh, you've never seen a TUI letter?
I have not.
Okay, this is a very typical TUI letter.
So I've heard.
Okay, so this is not a Miss Smith anything. This is the U.S. Attorney's Office protecting things, and it's an odd policy, but it's how it flows when you're dealing with the Fed. This one's a little bit of a stretch because I'm guessing TFO Ascu is an officer with some other force, and it hits an odd intersection because, well, what if the DA's office had, let's pretend that she's with Clayton County Police, I'm making it up. If they just subpoenaed Clayton County Police Detective Ascu, there's no TUI letter, but because she was wearing the task force hat, she was deputized, or whatever verb you want to use, as a federal agent, and so she does fall within the ambit of these TUI protections.
Understood. So, as I was saying, my first initial response was, what in the world is this?
This is nuts.
I figured out what it was. Then I looked at it and I thought, wow, basically this is saying, we'll allow Ascu, I'm assuming it's a lady.
It is a she.
Okay. We'll allow her to testify to what is good and safe for the state, but whoa, Ms. Wood cannot get into anything that she wants to find for Ms. Ascu. That was my initial thought when I read this. So that's obviously a confrontation clause issue. And then, of course, we also want to know, like, the procedure. I think I quoted
procedure?
I'm sorry?
What procedure?
Of, like, did they follow the procedures in the federal regulations? That's what I want to know. And further, why now? This case, everyone that's involved in this on their side has known about this since August 28th of 2024.
Known about what?
Whatever Ascu was going to testify to.
Oh, well, two letters come at the end because no one knew back then would Ascu need to testify because no one knew would there be a trial. And so I would push back and say they've known since maybe this hit a trial calendar. So
Last year, by the way.
okay, but then a trial calendar, it was really going to, I mean, there were other machinations going on, as you know, with your reveal the deal motion. And so I think this crystallized for the state, I'll call it this year. So this letter could have come a little earlier. It would have looked the same. And so what I want to know from you is what you think, and you have to crystal ball this a little bit because Ascu's not testifying yet, but in reading this, what had you thought about wanting to cross-examine Ascu about that you think you wouldn't be able to?
The thing that set off the most alarm bells for me was the text messages that are mentioned, the videos, anything. There was audio recordings mentioned elsewhere. That is concerning to me. Initially, my read of this is that I'm supposed to trust these attorneys from this Department of Justice to have an idea of what I'm allowed to get into on this case.
Oh, no, they don't think about it that way at all. And so sometimes a judge is confronted with a motion like yours, which is, you know what, this person ought not to be able to testify because we're not going to be able to develop a full picture from her testimony. And if she were the only witness to what happened at the scene and the state were resisting disclosing the CI, then you would have, I think, a more compelling argument, but we've got, I think it's Sergeant Patrick. There's someone from Fulton County, South Fulton Police will be testifying. So there are actually several people, and it may well be that there's a civilian testifying about what he knew about it as his role in the, so I think you aren't quite as constrained as it looked initially. But again, if there were areas that you were thinking, I can't wait for the TFO to get here because I want to ask about X, and then you read this and you say, well, I can't, like, let's say classified information. I don't think you were going to ask about that, but that's stock language. I don't think there's any classified information in this case, but let's just say that they learned about the drug deal from an intercept of a phone call from Iran. we don't get to ask about their knowledge about classified information communications from Iran. I don't think that's this case, but that's standard language that goes in there just to put those guardrails up so that the poor TFO, if she's on the stand and either side says, well, was there any classified information in this case? That person is trained to say, I can't answer that question. They don't confirm it. They don't deny it. They invoke that restriction.
Understood.
So again, as I read enumeration 1 and was thinking through how both sides would want to develop the connection of the CI to the August 2024 drug deal, that's pretty broad. And number 3, of course, there'll be no limitations on either side's ability to say, what did you see? What did you hear? What did you do the day of? Which is really what this case is about, as I think about another one of your motions about, well, what about earlier potential transactions between the CI and Mr. Terry or Mr. Adams? And we'll work through that as well. But I wanted to start with this because I didn't see excluding TFO Ascu, but I haven't been preparing your case. And so you might say, well, look, Judge, here are 3 areas. Like, oh, I hadn't thought about that. We may need to get Ms. Ben David on the phone and figure out, could we have a 1A so that Ascu can talk about X?
Understood, Judge. So if I understand where the court is headed with this, Ascu's coming in, but I'm allowed to vigorously cross.
Oh, yeah, you're allowed to vigorously cross. Where you need to flag for me, and it can be not right now, but it's a little late if it's once she hit the stand, but as you're thinking about things before she testifies, it would be, do I see areas where I feel like I won't get an answer from that question because Ascu will hold up her letter and say, I'm sorry, I can't talk about it. But if you look at all the bullet points, you're not going to be asking about federal grand jury information. This is a state case. You're not going to be asking about classified information, like I said, how the CI was recruited. That to me bumps up a little bit against 1, where 1 authorizes both sides to explore how the confidential informant came to be involved. I think you can get into an origin story. Was this person working with you all because there were charges, or was it money? But I think that's an acceptable area. But if you were to get into the specifics of FBI techniques for recruiting CIs, that is protected by this letter. But I think there is a meaningful distinction between saying, why was this CI helping you out? Versus what's the playbook for finding this person? Like, you go into prison, you learn that they have a kid, and you squeeze them. Like, if you ever want to see your kid again, cooperate with us. We don't explore that with this witness. All right?
Judge, I appreciate it.
Okay. Ms. Smith, anything you want to add about TFO Ascu and the TUI letter?
Nothing further to add. I'll just reiterate that the same parameters that state question are on the same thing defense can. So we're kind of both still on those limits on who we keep crossing.
That's true, and I saw that in your response, and that's a fair point. But I took Ms. Wood's motion to be, but if it's limited to, I'm making this up a little bit, if the letter were limited to, you can only say things that are good for the state. Of course you want that, and then the cross-examination would be, well, I saw Mr. Terry with the drugs in his hands, and he handed them to the CI, and can't go beyond that. That would limit there being a meaningful cross-examination. Okay, but where did the drugs come from? Or how did the CI, who gave the CI the money? Or did you count the money afterwards? Or things that would be germane, but this doesn't limit it that way. And so I think that, yes, you are just as limited. You don't get to ask about classified information or whatnot. And so it's a level playing field there. But I'm additionally finding that the field that has been demarcated is broad enough that I don't think it puts constraints on the ability of Ms. Wood to have a wide-ranging cross-examination of Ascu.
Yes.
All right. So I think we're aligned there. Ms. Smith, tell me the origins of why don't you describe what information you gave Ms. Wood on Friday after you got it? I take it came from Ascu. Hopefully it didn't come from Patrick. Is Patrick his last name? Yeah. So Ascu's on board, you get the TUI letter, and then somehow Ascu disgorges texts?
It was text messages, audio recordings, and also a video of the takedown.
Okay,
The videos and recordings were provided by Officer Ascu, not from the extractions and also not from Sergeant Charles Patrick.
okay. Where's Ascu's home base?
She's in Georgia.
Well, I didn't ask that well. Like her original agency.
Fairburn.
So she's Fairburn PD, but on the task force.
Yes.
Okay. And she gave you text messages that were between the CI and Mr. Terry. They're probably in the extraction somewhere, but you didn't pull them from the extraction.
From my understanding, the CI confidential informant's phone was not taken from the scene. It was not extracted. So
Right.
it wasn't a part of those extractions that we got from Patrick Charles.
But if he texted, are we revealing the CI's gender? Okay. If he texted Mr. Terry, then those texts are probably on Mr. Terry's phone. That was one of the phones seized, I think.
That's correct.
Okay, so I appreciate you didn't get it from the extraction, but it was probably extractable. And so Ms. Wood would have been able to find it if she had had more time with the extraction. The texts between the CI and Mr. Terry.
That's fair to say, because
Okay.
they did look for those extractions in Julian Terry's phone, did not see those, so we don't know if he had two phones, one phone.
Okay.
It's not confirmed, but
Okay, so it's texts. Is it 5 texts, 100 texts?
there are 2 screenshots of text messages between the confidential informant and the defendant.
That's it?
That's it.
Okay. And then you said there were phone calls.
Yes, we got a total of, I believe, 6 or 7 recordings from Officer Ascu. We're presenting 2 of those recordings throughout the trial today, if we're able to, but those recordings are from days before the meetup on August 28th, 2024.
Okay, and there are calls just between the CI and Mr. Terry, not calls to Mr. Adams?
That's correct.
Okay, 6 to 7 calls, 2 screens of texts, and then there was video, you said.
Yes, from the day of the takedown, there's a 37-minute video of the CI, within a monitoring device that law enforcement gave him to basically record the 27 minutes that led up to Mr. Adams getting there, and then what happened once he got there.
So it's like he has a body cam.
That's correct.
Okay, 37-minute video, which is CI body cam. Okay, and these 3 sets of calls, texts, and video, Sergeant Patrick never mentioned to you.
That's correct.
Okay, and they didn't come from him, they came from Ascu wearing her task force hat.
Yes, and in fact, when I first talked to her, she wasn't even able to disclose that information because she had to get authority from her superiors at AUSA to give me those documents.
Okay. All right, Ms. Wood, have you had a chance to review any of this late disclosed material?
Yes.
So the phone calls aren't just the day of, some of them are
Who
earlier.
knows when they are, Judge, because we don't know when this mysterious CI turned them over. We don't even know what day they were taken, who's actually on the phone, like on the other end. I mean, there's a million things wrong with the situation.
Okay, but like the call, the file doesn't say, August 12th, phone call.
Yes.
I will have to double check. I don't
Okay.
remember. I guess my head was spinning. So
I bet it was. How about the texts?
So the text message had, the one I'm looking at right now, it shows like a timestamp, but I don't see the date. And it doesn't show like a phone number because it's a WhatsApp text message.
Oh, what's that? Okay. But do they appear, you've had a chance to read them, do they appear to be contemporaneous to the day of the deal? Like, hey, I'm 2 minutes away from Wingstop?
Let me look at this first one. So one could infer that.
Okay. But there's not a date stamp on there.
Not that I see on this.
Okay. And then the video is a capture of what's going on in the immediate presence of the CI.
Yes.
And does it look like it's on his head, his chest?
I mean, my view of it was that he was like sneakily trying to record on his cell phone because he's like moving all around. It doesn't look like a body cam in my opinion, but
Okay.
yes, it's literally the CI's view. And if that comes in, I am going to be, obviously I'm asking for it to be kept out, but there's a lot of things that need to be redacted.
Okay. Hey there.
Morning, sorry.
That's okay. We're moving forward with some stuff anyway. What's an example of something on the video that you'd want redacted?
Discussion about my client's potential history.
As in criminal history or prior transactions between the CI and your client?
The glaringly that I remember off the top of my head was criminal history.
Okay.
Yeah, I mean, there's mention of obviously other things that need to be, it doesn't come in because again, it's hearsay. They need to blow their confidential informant if they're gonna get it in. And again, Judge, I was okay moving forward because the state has been telling me those cell phone extractions have been corrupted. I've sent screenshots of how it shows I cannot download the file. I move forward on a good faith basis that the state hasn't actually been able to review the extraction because I sure haven't.
Right.
And so that's the reason we're here, because I said, okay, fine, if they're not bringing in any videos or cell phones, like I'm good moving forward.
Okay.
And now, my client's at a disadvantage here, Judge, if these videos come in.
All right. Well, it sounds like the only thing that you or Ms. Smith, had she been able to get into the extractions, would have been the texts, maybe. Like the video isn't going to be on the cell phone. And the phone calls, there might be an indication that phone X called phone Y, but unless your client was recording his calls, you wouldn't have that either. And I flagged that only to say, this is even newer than the extraction. I think if the extraction had worked, maybe you would have found the text, and that's it. This other stuff you wouldn't have had. Okay. Ms. Smith, tell me how you think the calls or the video, more so the calls, would come in without the CI testifying, identifying, that's my voice, and the number I call, and I recognize his voice, that's his voice.
Yes, Your Honor. For starters, the state turned over all of the discovery that we had, even if it came late or not. We're under an obligation and a duty to give over any type of discovery that we got from any other witness or defense. So that's what we did.
I don't have any doubt that you passed it as soon as you got it. I don't think this is something you sat on. Law enforcement did because it's one of these federal local task forces. And so you run into these walls that they build that create these kinds of issues for the state and the defense, which is frustrating, but it's a side effect of some of these task forces.
Yes, but to answer your question regarding, and I'll take them separately, regarding the recordings from prior to the August 28th date, those calls will be authenticated by the task force agent, Ascu. She was the CI handler, and you'll hear through her testimony that she's worked with him, she knows his voice, she knows Julian Terry's voice from the prior dealings, and not prior dealings, but from that day of the bus. She was able to hear his voice, she was able to authenticate. And those are the two people on the call. The CI is unavailable. We will not be testifying today. The court, of course, the trial to reach out to the CI, but for sometimes by these reasons, the CI will not be here to testify. And regarding those statements on the recording made by the defendant, those are part of the opponent statements. So we believe, the state believes they will be able to authenticate those records based on task force agents Ascu's knowledge and her dealings with the CI, her being able to recognize his voice, and her having past dealings with the CI to get those recordings in. Regarding the video from the August 28th, 2024 date, that recording was made on a monitoring device that was given to him by law enforcement. And in my motion also, you would hear through Ascu's testimony, she was able to, as it was happening, she was also seeing it herself, and it was being quote unquote live stream. So she was seeing it as it was happening. She'll be able to testify and also authenticate that video because she was seeing it as it was happening. The CI is unavailable, and the other person on the other side of that screen was the defendant, Julian Terry. So when it comes to hearsay objections, we believe that it should come in under the exception of the CI being unavailable, and then as far as the defendant's testimony, the part of the opponent.
What about Ms. Wood's concerns about redactions? I don't know why Mr. Terry's alleged criminal history would have come up, but it sounds like it did at some point in the conversation. And there may be other things that ought not to be played. Have you watched it and identified areas where you think, whoops, we'd need to skip over this and skip over that?
Yes, Your Honor, we had a chance to look at the video multiple times, and we pointed out areas that we would redact. I just hadn't talked to Ms. Wood at all about the videos. That was the state's intention anyways. He's mentioning a court date he may have coming up or anything that may put too much of his business out when it comes to his criminal history. The state has no objection to redacting that information, but majority of that video doesn't contain criminal history, doesn't contain anything that would likely put him the subject of telling his criminal history.
And I'm not remembering exactly how Ms. Wood broke it down, but she said it's a 37-minute video, but a bunch of it, Mr. Terry's not even in it. It's just what the CI is doing to get ready, or he's hanging out, or am I misremembering it?
That's incorrect. where most of the video is a conversation between the CI and Julian Terry.
Because they're waiting on Mr. Adams.
They're waiting on Mr. Adams for about 27 minutes. So
Okay,
they're having-
that's what she said. Okay.
It was about 2 times where the CI went back to his truck, and at that time, he's saying, "Oh, I got this, they gave me this," he's reporting back the officer asking through the device. But the majority of the video, the CI and Julian Terry, they're having a conversation.
Okay. Got it. So it's a lot of statements by Mr. Terry.
That's right.
Okay, and you got all these things on Friday?
Yes.
Okay. All right. Ms. Rivers, are you ready to get on the record? Great, let's do that. This is State versus Terry, 25 SC 001921. It is Monday, the 23rd, about 9:30. Mr. Terry and his lawyers were here at 9 a.m. ready to go, as was the state. And we've been having an off-the-record discussion about some issues that arose over the weekend once the state was able to secure authorization from the Department of Justice to have Task Force Officer Ascu, A-S-K-E-W, testify. And one of the things we discussed was the TOUHY, that's T-O-U-H-Y letter that the U.S. Attorney's Office issued that puts certain limits on Task Force Officer Ascu's testimony. And I believe, Ms. Wood, in the end, you came away thinking, based on how I intend to apply the letter, that you don't right now foresee unreasonable limitations on your ability to cross-examine Task Force Officer Ascu. Is that a fair summary?
At this time.
Okay, you're not waiving anything. I think we're just deferring should something come up. But I think the letter gives both sides sufficient room to maneuver to explore fully what happened on August 28th of 2024, as well as what led the CI to be involved with the investigation and then ultimately to this transaction. So I think we're okay there, but we'll see how it flows. Ms. Smith, Task Force Officer Ascu is a witness for today or tomorrow?
Today should be the first witness to today's call.
Well, okay, then we need to work through some of this. So I think we're all right with that. Ms. Wood, you also filed a motion, I'm going to call 404B objection. And tell me if you are applying that to something more than what we might hear about, which is, tell us about the investigation, TFO Ascu. Well, we've been working with the CI for a while, and we were targeting Mr. Terry, and we actually had one earlier deal with Adams and Terry, and then it culminated in this deal. If that's what we're talking about, that to me seems kind of inextricably intertwined with this, but you saw the video and you've seen more, and I was wondering if you were aware of situations that Ascu or someone else might be talking about beyond what I see as the two that we've all been aware of, and that are linked in the sense that they're part of this investigation and one led to this bigger deal on the 28th.
Yes, Judge. So I think my main concern is that there's mention, and I think it might come in through Ascu.
And I didn't mean to limit it. If it shouldn't come in, it shouldn't come in through anyone. But this all seemed to bubble up from Ascu.
Sure. So there's mention in the main police report, which I think that would come in through Sergeant Charles, of a couple of different.
Is his last name Charles or Patrick?
Oh,
Charles.
okay.
Okay, so I've been calling him by his first name, so it's Sergeant Charles. Better get that right. Thank you.
So there's mention of an incident earlier in
Yes.
2024 of surveillance on a location they believe Julian Terry lived at.
Oh, right, you put that in, right.
There's mention of an earlier transaction where they write very vaguely that due to their intel, they believe that Mr. Terry sent some unidentified person to conduct a transaction with their confidential informant.
Right.
There's mention of an April 2024 surveillance that they were running on Mr. Terry's house. Again, very vague how they got any information about what they were supposed to be watching. And then, of course, there is a July 2024 incident. I think that's probably what they're using Agent Lynch for. But my concern is that if you take all of these, they're all separate incidents. They're all uncharged incidences. They could have charged them. My concern is that they were cumulatively bringing him in because obviously it goes to show character, or it's attacking his character basically here. To say like, oh, well, if he was involved in these prior 3 incidents, then he must have been involved in the August 28th incident. And Judge, I don't want to get off track, but I do have a question about something that was just said a few minutes ago about the confidential informant being unavailable. And I have many questions about that because I have no idea, as you know, who the confidential informant is. Is he dead, alive? Is he in prison? Where is he? I think the state is probably trying to get those videos in under a hearsay exception due to unavailability. And I think we are entitled to know exactly where he is if he's actually unavailable.
Okay. All right. We'll circle back to that. So Ms. Smith, Ms. Wood just went through a laundry list of, I'm gonna call them interactions, and they weren't necessarily that Mr. Terry knew that law enforcement was there, but pieces of the investigation that culminated in the August 2024 takedown. Which of those do you intend to explore with any witness? And is one of them the earlier deal about which we all learned during the suppression hearing on Mr. Adams's side of things, where there was a deal where the CI interacted primarily with Mr. Adams, but there was a Mr. Terry connection to that? Because that's the one that I saw as being a natural, where we stepped from that to this. And to me, it falls into the inextricably intertwined. Some of these, we watched the house and it sure looks like he was selling drugs. To me, were a little more problematic, but that was how Ms. Wood described it. And so I want to give you a chance to describe it as well, if you're even planning on using it.
Yes, Your Honor, the previous incidents or the previous sales will come in through Sergeant Patrick Charles. In this case, it wouldn't come in through Ascu because she's not permitted to testify about anything before August 28th. However, the prior meetup with Agent Lynch and the CI, and also with Winkler Adams and the CI, is what the state intends to talk about when they direct with Sergeant Charles.
Okay. So in terms of other law enforcement interaction with, surveillance of Mr. Terry, it's just 2. It's the main case, August 2024. And is it July? When was the situation with Mr. Adams and the CI?
That was also in August.
Okay.
August 2024. The incident with Agent Lynch happened earlier than that. I think in July.
What was that?
So that was another meetup with Agent Lynch and the CI. It's to the state's understanding that Mr. Terry told Agent Lynch to go to that location and sell narcotics to the CI. And we have her on our witnesses because Parker, when she gets on the stand and testifies, she'll talk about that experience and having to go to meet with the CI.
Okay. And this is something that law enforcement monitored, the Asia Lynch transaction.
Yes, sir.
Okay. And so the Asia Lynch transaction led to we'll call it the Adams transaction, which was then early August, which led to the takedown operation.
Yes, Your Honor. All of these previous incidents were controlled by, monitored, and observed by both Task Force Agent Ascu, Charles Patrick, and the whole South Force and Narcotics team.
Okay.
That's why it was all more so a bigger story to explain than to just talk about the incident that happened on August 28th, because we want to explain how we got here.
Got it. And Ms. Lynch, if she testifies, you forecast that she would say, I did this at the direction of, my words, not hers, at the direction of Mr. Terry.
That's correct.
And then if Mr. Adams testifies in this case, he would say that the early August thing, I did this at the direction of Mr. Terry.
That's correct.
Okay, again, those might not be the exact words, but sort of how it was engineered. And it's with the CI, each of the 3. And the CI is monitored, eyeballs on or ears on by Ascu and Sergeant Charles in each of the 3 situations. Okay, got it. These things about we surveilled his house and it sure looks like this is a drug house or there's drug activity, you don't intend to get into that?
I'll ask Sergeant Charles about his investigation. He may mention the surveillance, but I don't intend to ask him more about it. When I talked to him about the vagueness in his police report, it was written that way because at that time they were dealing with the CI. So it was different things in the report that they couldn't be too specific on. However, if he talks about them doing surveillance, I don't intend to ask him more about, well, why, who did you get this from, what did you all see? He'll just be giving a summary of his investigation.
Okay, and he won't be speculating, because that's what I saw, is that a couple of the earlier observations, as they were described by Ms. Wood, sounded like it was law enforcement speculation. Like, hey, I saw cars coming and going, sure seems like a drug business. And it doesn't sound like you'll be asking him to say, what did you see? What's going on there? And in your experience, what does that tell you? You're not intending to go there.
That's correct, Your Honor. He'll probably mention it because he was the lead detective, oversaw the investigation. So yes, there was surveillance in Mr. Terry's home, but not exactly what they saw, what the camera recorded or whatever the case may be. We're just solely talking about primarily the incident between Agent Lynch and also Wycliffe Adams prior to August 28th.
Okay, so my direction to you is to, unless Ms. Wood opens it up on cross, when you are talking with Sergeant Charles about the preliminary phase of the investigation, you can certainly ask, was there surveillance, but don't follow up with, and where was it, something like that. Did you see Mr. Terry? But not, and what did you conclude from that? Or did you see anything suspicious? It's just I'm gonna call it neutral investigative fact that we did surveillance here, and you're just describing how the investigation moved along to then 2 control buys and then ultimately the takedown. All right, Ms. Wood, tell me your concerns about that if we do it that way. So the only way the Asia Lynch alleged transaction comes in is if she testifies, so you can cross-examine her. Same with Mr. Adams. And the precursors to all that about drive-bys or surveillance is as generic as I described it. As they're saying, yeah, we had this lead, so we did surveillance, and that led to a July situation and 2 August situations.
Yes, Judge. However, I just want to point out, I think, so the earlier August 2024 incident that is in Sergeant Charles's report doesn't give an exact date, it gives a location, and it literally just says, we received intel that another unidentified subject was being sent by Mr. Terry to meet with the FBI CI. Does not say that Julian Terry was there at all. So it does say that Wycliffe Adams was there. So I understand if Mr. Adams is on the stand, but I just want to be clear because I think I might have misheard something, but I just want to be clear that there's no testimony that Mr. Terry was there at the early August 2024 incident.
Well, I mean, if there is, that's Mr. Adams saying that, and then you can open up the can of worms with Charles, like, well, what's going on here? What? I don't know what Mr. Adams is going to say. My recollection from evidence that we've heard on that side of the case was that Mr. Terry was not there.
Got it.
But I'm not locking anyone in. You may get inconsistencies, which is only good for you. But more importantly, you're going to control in some ways how deeply the state can go into anything other than the Asia Lynch and the Wycliffe Adams through your cross-examination, because I'm limiting the state that unless you open the door, these other things are, we did do surveillance, we established this was an address and he drove a blue Malibu, whatever it is they learned sort of factually, but not then their speculation of that was really suspicious that this truck backed up and then all these customers showed up. Okay, sure. Yes, ma'am.
I have a quick question, just to clarify. I know, Patrick Charles was not testifying to the surveillance they did on Mr. Terry's home. However, when it comes to those 2 previous controlled buys, is that something that the court is saying, Sergeant Charles can speak about without representation?
As long as you are also calling Ms. Lynch and Mr. Adams, then yes, because then people will get the full story. I mean, if he was there and watching it, then he can certainly talk about what he saw. But if he is saying, and Lynch showed up because Terry told her to, he knows that because Lynch told her. And so that's why you would need Lynch. So I'm not in any way precluding any law enforcement officer from saying, here's what I saw, and here's what I heard, if it's something Mr. Terry said. But if it is, and I know that Lynch did this because that's Ms. Lynch telling him. And so at some point, she would need to testify as well.
Okay.
And then you might be rehabilitating her if he testifies afterwards because she gets bruised in cross-examination. Then you could get in her prior consistent statement to, I mean, all the ways you might want to. You'll just need to think through the order in which you call these people. But no, I wasn't saying that law enforcement couldn't talk about what they observed at either the July or the 1st August transaction.
Oh, and I just wanted to clarify that the testimony of Sergeant Charles was not that Agent Lynch told him that, but that's what the conversation was between him and the CI when they came in to debrief after the transaction.
So how do you plan on getting in anything the CI says if the CI is not going to testify? For the truth of the matter asserted, if the CI, let's say you had a recording of the interaction between Sergeant Charles and the CI said, whew, I was scared. I mean, was he scared or not? Who knows? That's what he said. He may not necessarily offering it for the truth of the matter asserted. But if he says, this is why it went down and Lynch told me this and that, I think you're wanting to get it in to prove that that's what happened in the deal. And that would, to me, would be hearsay, which I think is one of the bases that Ms. Wood is seeking to keep out. Also, these late disclosed, not by you, by the FBI, recordings. And this to me would be in that same category, that if Sergeant Charles knows something only because the CI told him, and you're offering for the truth of the matter asserted, then it's hearsay, except for unavailability. And then if you want to rely on that, you do need to make a record now as to why the CI is unavailable.
Yes, Your Honor, when it comes to the hearsay objection, the state would be contending that because the CI in this case is unavailable, that's why his testimony should come in under hearsay, and also when he told those conversations, but had the conversations with Charles Patrick, that was a direct conversation that he remembers he was there for. When it comes to setting the record regarding the CI's availability, I'll kind of tell you the timeline of what the state went through to try to get the CI. We first reached out to the task force agent, Ascu, to ask her about how do we acquire getting the CI to testify for the state. She then gave my message to AUSA, I think her name is Defendant, and we talked, and he said that usually the CIs are not released to come and testify, but that he would double check with his superiors. He then gave me a call back and clarified and confirmed that the CI in this case would not be able to testify. He said that he is in federal custody, however, we don't even have any additional information regarding where he is. It's coming from the AUSA's office. I spoke to the CI's defense attorney also, who stated that he was federally indicted, but there was nothing else that I knew about his whereabouts. I think as far as the record goes, we've reached out to both the task force agent Ascu, the AUSA office, and also the defense attorney of the CI, and we have not been able to obtain him for trial based on him being federally indicted and not been able to be processed and produced for this trial.
Okay, got it. Do we have all our jurors? Okay. I'm glad this is a short trial. So Ms. Wood, we still have to work through what to do with the late disclosed materials that flowed through TFO Ascu. They were late disclosed. I don't find bad faith, but then the remedy would be to say either given when they came, it's more of a problem for the state. We could say they can't come in day one, so you have a time to digest them more. What would more time get you? Let's say that I said, you know what, I'm going to explain to this jury and appreciate what they did, but we can't go forward. And we pick another jury in a month. What would, and assume the CI remains unavailable. Doesn't sound like he's going to be showing up anytime soon. You might have some of the same objections. Things that he said could still be hearsay, because I don't know, I'm stuck in federal custody and my federal handlers won't let me testify. Counts as unavailability under our hearsay statutes. But other people could authenticate some of these things. Let's just take phone calls. There could be witnesses who could testify today, and the same witnesses could testify in a month and say, I recognize that as Mr. Terry's voice. And so the CI's half of the conversation just comes in for context, not for the truth of the matter asserted, and the focus is what Mr. Terry said. What would you be doing differently a month from now concerning those phone calls, if they could come in even though the CI wasn't testifying? If that makes sense.
I mean, again, Judge, the confrontation clause, which is one of my client's constitutional rights, is affected here. And also, this is brand new information to us that this confidential informant is in federal custody. That's huge. The state has never once mentioned that to us. Granted, I didn't ask, but again, it's not my problem to do their work for them. Yeah, we need to be able to cross-examine who made the videos. And if this confidential informant is not coming in, they're not burning their CI, then we're disadvantaged. We're supposed to rely on, oh, well, we trust the CI and this is like his recording and we trust that that's Mr. Terry's voice on the other end, even though I don't have phone records. I don't know where it came from, when it came. That's my position, Judge.
Okay. Were there other issues that you wanted to discuss this morning?
I'm sorry, Judge.
That's okay. You had 4 motions, and I think we've covered everything. We talked about 404B. We've talked about the CI. I haven't ruled yet. I will in a minute. We talked about the late disclosed materials. And so I think those were the four.
Yes, Judge. So given that the court has not ruled yet, I'm wondering if the court put some parameters in place for the state's opening.
I'm gonna rule before opening so
Okay.
people know.
Got it.
I just want to give everyone a chance to, I'll make sure I didn't miss anything. Ms. Smith, is there anything more you want to cover?
I want to address the confrontation clause issue. State believes since TFO agent asked me to be able to take the stand, she has a set of parameters that she can talk about. One of those being the day that the defendant is indicted for August 28, 2024, which is the reason we're here today. The defense attorney will be able to cross-examine and ask you on exactly what she saw that day, what she didn't see. It's not something where her testimony only helps the state. She's able to talk about the entire observation of August 28, 2024. So when it comes to the confrontation clause, the state believes that the defendant does have a meaningful opportunity to cross-examine TFO Ascu under the parameters of what she can talk about, which is the same thing that the state will be directing her on. We're not going to be allowed or have more leeway to talk about more things in this investigation that the defense can't.
Okay, I'm Ascu's going to testify. I'm not concerned about the breadth of cross-examination that the defense has. And I didn't hear Ms. Wood saying, well, I don't get to ask what the state gets to ask. If you get asked about X, obviously she does as well. I heard the concern being, well, but maybe the state just wants to ask about A and B. I want to ask about C and D, and they're relevant, she believes, but the letter doesn't allow that. But I don't find that issue to have arisen. I think that the way the letter is crafted, Ms. Wood will be able to explore relevant material with Ascu. So Ascu's testifying.
That's correct.
Don't worry about that. And she'll be able to confront Ascu because Ascu's testifying. I'm wrestling with the CI, who I don't find is legally unavailable. So that's not the way things that he said would come in. Would you use the video if the audio didn't work?
Yes.
Would you play all 37 minutes of it, or would you play some lesser part but have Ascu or Sergeant Charles narrate? Well, what do you see here? This is the CI's left hand, and that's Mr. Terry, and that's.
Yes, Your Honor, we're not able to use the sound in this case. It would just be narration through TFO Ascu in this case.
Okay.
And we wouldn't use the entire 37 minutes. Although the entire 37 minutes is relevant to the takedown of that day, if we're only limited to talk about, or limited to only play the video without sound, we would be only showing a portion of that video.
Okay. Ms. Wood, tell me what you would do differently if we tried this case in a month, and the only thing that the state could use from the late disclosed material was the video part of the video. So no audio, just press play. And it doesn't sound like they play all 37 minutes, but you could play any part of it as well, but with no audio.
Judge, I don't have an issue if it's no audio going. I don't think I would have an issue with that.
Okay. And on the texts, did Mr. Terry's phone got seized, so you haven't had an ability to go through. I don't know how WhatsApp works. I'll admit to that. I know what it is. But I'm curious if the way it works is that Mr. Terry could have gone online, not using his phone or using a different phone, and logged into his account and obtained these, so that the texts are actually something he or you could have obtained through other means, if that makes sense. Because if the only way you could do it is through his phone and his phone was seized, I'm gonna handle this differently than, yeah, you know, we could have, maybe should have poked around in that account. Like your Instagram stuff.
Your Honor, so I have an issue with, now that I'm looking at this more closely, so the first.
This is the text?
Yeah, the two text messages. So one of them is actually a screenshot of a text, so the screenshot of a screenshot. So whatever screenshot is.
Can I look at it? Does someone have a hard copy?
I don't.
I have it on a flash drive, but to be clear really quick, the state doesn't intend to use these text messages throughout trial. We never,
Oh.
or that we wanted to use it. The only thing we were doing, like I said earlier, is that when the state gets discovery. it's
Got it.
information from-
Okay, you don't intend to use the text. Oh, all right, okay, thank you. I didn't, but you did the right thing, obviously, by handing everything over. I didn't know. So the text you're not interested in, but they're disclosable. It was the calls and the video.
That's correct.
Okay, all right. For purposes of your opening and handling witnesses, here are my rulings. I'm happy to revisit any of this as things evolve, because they could change based on questions the defense asks or things we learn. But TFO Ascu is going to be able to testify, obviously limited by the TUI letter, but I don't think that limits her to a point where her testimony should be precluded. And TFO Ascu can talk about things that the CI did. She cannot talk about things the CI said unless there is a hearsay exception other than the CI is not available. The state may present evidence about the basics of the investigative work that Sergeant Charles did, meaning that there was surveillance, things like that. Should Ms. Lynch testify, so we're getting her words and not what the CI told Askew or Charles, the state can get into what I'm calling the July transaction and talk about it in their opening. Should Mr. Adams be testifying so that the jury would hear from Mr. Adams and not from Charles or Askew about what the CI said, the state can get into the earlier August transaction. And obviously the main August transaction, they can talk about in all sorts of ways. That addresses the 404B concern. There's no need to reveal the CI because the CI isn't going to be here. In terms of the late disclosed materials, if the defense wants to use the text, they can. The state's not going to be using them. The phone calls cannot be used even though they contain the defendant's statements because they are late disclosed. The video can be used as video only, no audio. I, again, don't find that Ms. Smith or her team has done anything other than as soon as they got it, they passed it on. They were kind of procedurally handcuffed by the way things work when there is a federal partner in what ultimately becomes a local investigation. Now, Ms. Smith, you may need to retool a couple things in your opening, and you may need to let witnesses know about the limitations on their testimony. And so you or one of your trial partners can talk with them. We can take a quick break because we've been going for a little while. But do you feel like you understand the parameters as I've described them?
Yes, sir.
If you think something changes because of what a witness says or something the defense does during a break, or if we need to have a sidebar, let's do that. Because you may say, hey, now based on that, I think I should be able to get this phone call in, and here's why, or who knows what. Especially if Mr. Terry chooses to testify, that may open doors that wouldn't be open if he does not testify, in terms of your ability to use some of those materials. Okay?
Yes.
Anything else from the state?
Yes, I would like to approach regarding that, regarding the witness.
Okay.
Other than that, if we can get a break before we get a break.
Okay. Ms. Wood, anything you,
I'll defer to Ms. Feely.
Ms. Feely?
This is just a point of clarification, not
Yes, ma'am.
causing problems, but in terms of the CI, normally with the confrontation clause, we would get to cross-examine him or her about
We've determined it's a him.
him.
Yes.
Where he is, why he's there. We would be able to get into his criminal history, and we would be able to get into what he got for being a CI.
Mhm.
We're not getting to do any of that unless we can get it out through another witness, but I think it's very, very relevant for the jury to hear all of those things.
I think so too. And I think that paragraph number 1 in the TUI letter allows that to happen. And you may not have been here, or I wasn't clear, but that paragraph reads, how the confidential informant came to be involved in the 8/28/2024 operation. And to me, that would include, why is this person working with FBI, local authorities, trying to work off federal charges, maybe hoping to get a better deal? Now we know it's federal charges. And so now Askew may not know all the details. Askew may not be able to say it was gun running versus tax fraud versus who knows what. But I don't think either side is precluded from exploring that, because that explains how the CI came to be involved. It's not just he was walking down the street that day and they're like, hey, we need some body doubles in here. There was a reason why he was working with the authorities, and you can explore that, just not by asking the CI. And of course, the flip side, that's the downside for the state, is there are all sorts of things that it sounds like Mr. Terry said to the CI that we know about through their communications that were only disclosed by the federal side of the investigation on Friday late. So did that clarify?
I just want to make sure that we're not going to get into a situation where Ascu's like, I don't know. And then,
But that could be the answer.
right, but then they need to stipulate to why he's there and for what reason. All the things we would be able to get into through the confirmation clause. So I think we need a stipulation from the state if she's going to be up there saying, oh, I don't know his criminal history. I don't know why he's in prison or where he is. Because that's stuff that we should be able to get in front of the jury.
Well, yes and no. It is possible that the CI was arrested after this for having 40 unregistered guns and a kilo of coke in his place. And the CI went south on them. It turns out that he was playing both sides and so that could be why he is sideways with the federal government now. And Ascu may not know the answer to that, but I don't think it's right to assume that the CI is in federal custody right now in connection with why he was assisting. So if Ascu doesn't know, Ascu doesn't know. I don't know that the state has to stipulate to something that the state doesn't know either. But I don't think there's any reason why Ms. Wood couldn't say, well, the CI is in federal custody right now, isn't he? And Ascu may say, I don't know, but she can ask that question.
But that's a problem. Yeah.
Okay, but how do you propose fixing that? Because that's not necessarily a correct stipulation unless the state knows better, that the CI is in federal custody right now, facing federal charges. And the hope is that that goes better for the CI because of his assistance in this case. That may be true, and that may be known to Ascu, but if Ascu doesn't know that and it's not true, who's writing the stipulation?
Well, this is the problem with having a witness that's not going to testify. If they can't bring witnesses to prove this case, then that's a state problem, but it can't be used to hamstring us by saying, well, the jury can just think that he's a choir boy from wherever, and we won't be able to get into, if she says, is he in federal custody? Or he's in federal custody, isn't he? I don't know.
Well, what's the confrontation piece if, as I believe I've ruled, what the CI said isn't coming in? An example that Ms. Smith asked about was, well, if the CI told Sergeant Charles, here's what the Asia Lynch deal was all about, can't Sergeant Charles talk about that? I said, no, Asia Lynch can talk about it. And Asia Lynch can say, Mr. Terry told me this, and I interacted with this guy who I knew as Rico, who is, I'm making that up, is the CI. But if nothing the CI said is coming in, there's not a confrontation issue. Things the CI did will be coming in, but you don't, I mean, that in every trial, there are witnesses who don't testify, but people describe what they saw those individuals do, and they could be choir boys, they could be mass murderers. We don't get into the criminal history or lack thereof of people who aren't here testifying.
But I think that's for the jury to determine the credibility of that person and for us not to be able to get his NCIC and figure out what convictions he has, just like we would if he was a live witness. I think we are still entitled to make the jury see where this person is and what their biases are and all that.
Got it. Okay. You've noted that. I find that based on my rulings and exclusion, I'm not excluding the CI. The state's being told by the federal authorities they can't use the CI. But that doesn't mean people can't talk about what they saw the CI do. And that's how this trial will proceed. But I am keeping out at this juncture things that the CI said. That's why the video is video only. And that's why the phone calls aren't coming in at this juncture. You may pivot partway through and decide, you know what, actually we want to use a couple of those phone calls. All right, maybe there's a way to do that. But actually the side that I think is hamstrung by my rulings is the state. But appropriately so because of the late disclosure. They can't get in calls that I presume are your client saying, let's do this deal. It's this much money for this much drugs. That's a bad phone call for your client. And it's not coming in because you're not going to be able to cross-examine the guy on the other side. So I hear you, but I think my rulings have protected against the fact that the CI won't be here. Ms. Smith.
Yes, Your Honor, just want to clarify, I did have a conversation with TFO Ascu about what she could testify to in her limits. She did mention that one of the things that she could not testify to because of the two letter was any incentives that the CI may have gotten from their assistance with South Fulton. That's just what she told me based on the parameters of the letter. I know one of the concerns for the defense is to talk about the history with the CI or to get more into how she dealt with the CI in the past or things like that. However, from my understanding, talking to TFO Ascu, based on the TUI letter, that is not something that she can disclose on direct or out of cross examination.
Okay. Well, I guess what we'll need to, is she here? Is she outside?
But she should be. Okay.
Okay, if she's outside, maybe she could come in and we could ask her a few questions. Hi there. Okay, if you could come on up to the witness stand, please. There are no wheels, you gotta pull hard. That way you don't roll off.
Okay.
Are you Ms. Askew? What is your, with Fairburn Police? Are you detective, a sergeant, officer?
I'm an investigator.
Investigator, ask.
I'm a task force officer.
Okay. Do you want to be called Task Force Officer Askew or Investigator Askew?
Doesn't matter. Investigator Ascu's fine.
All right, Investigator Askew. I'm Judge McBurney. And you are going to be testifying in just a little while in this case. And we needed to work through a couple of questions. We've been talking about the TUI letter. And so if you had been an investigator with Fairburn, we wouldn't have to work through all this. But for the purposes of this investigation, you're a task force officer. And one of the areas that the two sides were curious about their ability to explore is not how the CI was recruited, and certainly not who the CI is, not going there. But the first thing you're authorized to talk about is a pretty broad bucket, how this confidential informant came to be involved in the operation, which to me meant, well, what's the origin story of the CI? Not how that person was recruited, but why that person was willing to do something risky and not what most of us would normally be doing. And that's because this person is just a good person or got a vendetta against the defendant or is facing charges or whatever the situation is. To me, that falls under number one. But Ms. Smith said that as she was talking with you about what you understood the limitations to be, you felt that if you knew the answer to the question of what's in it for the CI, you weren't able to answer that question. Not because you didn't know, but because you felt you were restricted by this letter from doing so. I didn't see that in the letter, but we wanted to discuss this outside the presence of the jury to minimize the number of times you have to say, I'm not allowed to answer that question. Because that's always weird for everyone. Like, what do you mean you're not allowed? The judges. So tell us what you understand the situation to be.
So my understanding based on this TUI letter is that I can't discuss anything regarding the CI outside of the August 28th operation. So let me make sure I'm answering your question. Your question is what led the CI to provide information to us, whether it be source consideration or sentence consideration or
money. I mean,
yeah,
right. People do it. Right.
Yes. That is the only one question that I have not got clarification if I could disclose that. So if I can step out, I can actually give a call. That is the one question that I do not have.
Okay. I'm going to let you do that, but I want to cover one other thing because it seems contrary to how I read paragraph 1, how the person came to be involved. I believe that the state is going to want to talk about 2 earlier transactions in which the CI was involved. Was that not through TFO Ascu? Was that going to be through Sergeant Charles? Oh, okay. Then it doesn't. All right. Okay. Because that still would be how the person came to be involved with the August 28th is that these things sort of culminated in the larger deal. And to me, that falls real comfortably within number 1, but I didn't write the letter. Yeah, if you could let whoever you know call that it's pretty central to the case, not to get into the details, but what was the, was it monetary or charge related or what? That's something that both sides, well, Ms. Smith thought you weren't able to go there. I thought, well, it says you can't talk about recruitment generally, like, we troll around in these neighborhoods and do this or whatnot. But for this person in particular, how did you come to be involved on 828? Because I'm in trouble with the feds and I'm trying to reduce my exposure in a different case. Goes to why someone might be involved with a situation like that.
So, yes, sir, I understand that completely. Just for clarification on my end, when I make that call, is it just going to be a straightforward answer, either money or considerations? We're not going to go into further details of what other sentencing, what consideration or sentencing he had? Or
Well,
he or she had?
do you already know those answers?
No, sir.
Okay, so if you would be getting it from the person on the phone, then we wouldn't go there.
Okay.
Because if your answer is, I don't know, we just wanted to not ask the question if your answer was going to be, I can't tell you that
So
answer.
We did not pay the source any money.
Okay,
So that could answer you right then. We
Okay.
did not provide money for any information.
got it. But like we've learned that the source is in federal custody now. And so that's led to thinking, maybe this was done in the hopes that that would help the source with the federal situation.
And
And that's really all the sides want to be able to say, that there's a reason for doing it. Apparently it wasn't money. It was a hope for a future benefit in connection with federal charges.
yes, sir.
And if you already know that answer and you want to get clearance to give it, that's what we'd like. If you don't know the answer, I don't want you to go get the
Yes, sir. I
answer.
just need clearance.
Okay. If you could get that, and then you believe that this letter does not authorize you to talk about how the CI ended up being at Wingstop was because he was with Mr. Adams 2 weeks earlier.
No, I can discuss what led up to the Wingstop. I
Okay.
just can't go into details on any other operation outside of the 828. Like I can discuss that there were conversations involving the narcotics purchase for the 828.
Okay.
There was text messages that were discussed.
Yeah, we're not getting into those because of other issues. But as I understand it, there was earlier in August a drug transaction that involved Mr. Adams. And Mr. Terry is allegedly connected to that, and the jury will learn about that however they learn about that. But the CI was involved, and so presumably you were involved. And so the state intends to ask someone, but maybe it's not you, maybe it's Sergeant Charles. Okay, but you can't talk about anything you did in connection with, I call it the earlier August transaction.
No, sir, I can't. But if the audio is played, I can authenticate the audio where on the 828 previous transactions were discussed.
Right, the audio is not going to be played. So
Then, okay.
there we go. Okay, is there anything else, Ms. Smith, I don't want Investigator Ascu to call the powers that be more than once. So we're going to find out, can she share, and if so, what can she share about why the CI was working the way the CI was working?
I think that'll be all. I don't have anything extra for her to add or to ask.
Okay. Ms. Wood, anything, or Ms. Feely?
No.
That's it? Okay. If you would check. And you got time, we're going to bring the jury in and do some other things. If you could just get word, do you have an investigator or someone, Ms. Smith, who can get the answer from Ms. Askew and then bring it back to you so you can let us know?
Yes, sir.
Okay, great. That way we don't need to wait on the call. All right, thanks. Anything else, Ms. Smith, before we bring the jury in?
Nothing further.
Okay, Ms. Wood or Ms. Feely or Ms. Rios, this is the largest legal team ever.
No judgment.
Don't argue ineffective assistance of counsel. All right, I think then we're good. If you could check on those jurors.
Judge, quickly, there should be a break before we start our presentation at evidence, so I can reach out.
Oh, yeah, I forgot about that. Can you, yeah, I need to give you the break. So, yeah, if you could just get Deputy Gordon to poke his head out. I forgot I told the lawyers they could have a quick break.
Okay, I take you to the rest of the.
Good, okay, good. Keep rallying them and let's take a quick break and we'll be back is 5 minutes enough? You got lots of lawyers here.
Yes.
All right.
Okay, thank you.
Right here, I have eyes on both of them, the doors are open.
Okay.
They're walking in slowly, but they're walking in.
Okay, thank you. We were worried the next person going out, we were going to hold a rope as they went out, so we could pull them back in.
Both my phones here, so I was for certain coming back. They come back to find me or I need to find someone.
All right, Ms. Smith, are you ready for the jury?
The state would like to approach one more.
Oh, right, we had to approach about something. Like go out in the hallway?
Yes, please.
Okay. Then we can bring the jurors in? Maybe. Okay. Mr. Adams, if you and Mr. Tevis would come up to the podium, please. Morning.
Good morning.
We're going to get on the record in your case as well. It's 25 SC 001921. And Mr. Adams, Mr. Tevis, very helpfully shared with me that you have been thinking about some of the decisions and choices you made and are thinking about withdrawing your plea if in fact the state is going to call you as a witness in its trial. And I do believe that you would be called to testify, but because we deferred sentencing until after Mr. Terry's case was over, you've got the absolute right to withdraw your plea. I just need to make sure you are aware of, I'm going to say consequences, but it doesn't mean you're in trouble. There's something, it's your right to withdraw your plea, but there's certain events that will naturally flow from that. But let's go one step at a time. One, have you had a chance to speak with Mr. Tevis about what you're thinking about doing?
Not fully yet.
Do you want to talk with him a little more? Let me share a few things and you can tell me if you want to talk with him a little more and you can take that time. You don't have a ton of time because we've got 14 jurors who are ready to come in to start State versus Terry. But that's a case in which you'd be testifying. If you choose to withdraw your plea, which you have an absolute right to do at this juncture, then we would revert back to it's a two-defendant case. You and Mr. Terry would be tried together. We would likely delay trial for about a month. There is some newly produced material that needs to go to your lawyer and just recently got to counsel for Mr. Terry. And then the state would work on getting the confidential informant produced from federal custody so that the confidential informant would be in a position to testify at this later trial. But the main difference would be instead of having pled, you're going to trial, and you would be going to trial with Mr. Terry. So you and Mr. Tevis would be at the table, and Mr. Terry and his legal team, maybe one lawyer less, would be seated at the table. Did you want to add something?
Yes, without a laundry list, just because we weren't here this morning, could you give us an indication of the nature of the additional items that have been turned over? I know there's some text messages.
Sure. So what was turned over late Friday, because the state just got it then, there were about a half dozen phone calls supposedly between the CI and Mr. Terry. There were a couple screenshots of WhatsApp texts between the CI and Mr. Terry. And then there was a 37-minute video. The CI had a recording device. I call it a body cam. It obviously wasn't obvious, but it allowed there to be video and audio to be recorded when the CI was at Wingstop. Apparently, the majority of it is the CI and Mr. Terry just chewing the fat because they were waiting on Mr. Adams to arrive. And then the last few minutes are the actual transaction. So video and audio from the CI's person of what was going on at Wingstop, half dozen phone calls, some of which precede the actual transaction on the 28th, and then a few screenshots of texts. All of that is CI to Terry or Terry to CI. I'm going to ask the task force officer if she's in a position to acknowledge whether there's any CI to Adams communications, because those would need to be disclosed as well, ideally not on the eve of trial. I just don't know if those exist. I'm telling you what we know exists, and it's all CI and Mr. Terry. Mr. Adams may appear on that video, but the calls and the texts are CI and Terry.
And I caught a little bit of the YouTube on my way in. There was discussion of a TUI letter and a federal agent. Is there now an intention to produce the CI? We don't know that.
Yeah, you were also a little late back there, but the plan would be if we go forward with the joint trial, I'm calling it about a month out, whenever it would be, the CI would in fact testify. which would fix a lot of the issues we were working through today, where the defense was concerned, well, how do you get these phone calls in? And the audio portion of the video, where it's chatter between the CI and Mr. Terry. Some of it could be authenticated because some of law enforcement say they're familiar with Mr. Terry's voice. But if the CI said anything that they wanted to use for the truth of the matter asserted, it's problematic. Those issues would go away. So no one's guaranteeing anything, but what the state shared is that if we don't go forward today, which we won't, if in fact there's a plea withdrawal, then it would be try the defendants together with the addition of the CI, most likely at take 2 of this trial.
Very well.
Okay. So, Mr. Adams, again, I'm gonna let you and Mr. Tevis speak real briefly, but just so you understand, no jury would hear that you attempted to enter a plea, nothing like that. That is something that occurred, but the jury would never hear about it. You'd just be sitting as a defendant with a presumption of innocence in his favor, and Mr. Tevis as your advocate for the trial, if we did go forward with the trial. You understand that? Yes?
sir. Yes, sir.
Okay. Any questions about anything I just shared with you?
No, sir.
Do you want to talk with Mr. Tevis for a minute?
Yes, sir.
Okay, if you guys want to go outside. Is Investigator Ascu out there? Well, how about if you want to take the first swipe at it? Would one of you see if there are any similar materials involving Mr. Adams that would be disclosed if the trial involves Mr. Adams? I don't know if she can answer that question, but we can at least ask. All right, let's get back on the record with Mr. Adams. Mr. Adams, did you have enough time to speak with Mr. Tevis?
Yes, sir.
And you feel like you understand how things will flow if you do withdraw your plea?
Yes, sir.
And is that your intention?
No, sir.
You want to maintain your plea?
Yes, sir.
And you will testify today?
Yes, sir.
Okay, all right. You understand you can't change your mind mid-testimony?
Yes, sir.
That will create all sorts of unpleasant side effects for you.
Yes, sir.
Understand? Okay. Ms. Smith, was Mr. Adams going to be testifying this morning?
Yes, Your Honor.
Okay, great. All right. If you guys will take a seat. Actually, you need to wait outside because you'll be testifying. So it's a bit of a roller coaster. My thought is with that announcement that Mr. Adams is going to testify, that we move forward. Ms. Smith, anything you want to get on the record in connection with moving forward or not moving forward? Okay, Ms. Wood.
Yes, Judge. I know last week when we had our discussion about the motion to reveal the deal, you instructed the state, hey, if anything changes about if anything was promised to him, it needs to be out in the open and shared. Ms. Wood, I just want to bring that back up and see if anything has changed in that regard today.
Sure, nope, fair question. Ms. Smith, are you aware of any new dimensions to the relationship that Mr. Adams's case has in connection with his potential testimony? Okay, all right. If that changes, you'll let Ms. Wood and me know?
Yes.
Okay, all right. Then let's bring the jurors in, please.
All right, so jury. Who's the president of the county for?
Thank you, Deputy Gordon. Everyone else can be seated. Good morning, jurors. Thank you for being here mostly on time. I am sorry that we had you sit back there in the jury room, other than it was a nice forced mixer as you got to know each other. When the trial is over, I'll be able to talk to you more about the several legal issues that the lawyers and I were working through. But let's just say there were several, and they were complicated, and they came up over the weekend. So this was the first time we could tackle them, and they took longer than I thought. I appreciate your patience. But we are ready to proceed. Here's how today is going to play out. In just a moment, I'm going to administer the juror oath, makes it official, you're jurors, and we're underway. Then I'm going to give you a little bit of the law that you must apply to the facts as you find them to be, just basic operating instructions about burden of proof and a little description of how the trial is going to flow. Not in terms of what the evidence is, I don't know that, and you don't know it yet, but sort of how the two sides do the things they're going to do. And then we'll be underway. The parties will give their opening statements and we'll press on. We're going to break for lunch like we normally would. It just means we're not going to get a ton done before we break for lunch, but we'll probably break for lunch a little later than usual. If any of you were on panel 2 or panel 3 from Thursday, it's not a lunch break like that. It's not 3 hours. We try to keep it to about an hour, but this first day, since you haven't been to whatever the closest restaurants are, it's usually about an hour. And then tomorrow we may shorten it a little bit if you want to have things move along a little faster. But again, thank you for your patience. We had a few unexpected issues arise. If you could all stand, I'm going to administer the juror oath or affirm that you shall fairly try the issue formed by the indictment. I'm going to hold up because I'm going to read to you in a minute. By the indictment between the state of Georgia and Julian Terry, who is charged with trafficking in methamphetamine and possession of drug-related items, and give a true verdict according to the evidence. Please say yes if you so swear or affirm. Yes. Does anyone not so swear or affirm? All right. So you can take a seat. From here on out, you did it this morning, you enter and leave the building by coming to the jury room first. So just like you did this morning, you hit that button. I let a few of you in before my staff was here. You hang out in the jury room until Deputy Gordon brings you into court. He will bring all of you in together. We will never conduct court with just some of you. We need all 14 of you present, which means if 13 of you get here at 9 in the morning and one of you straggles in at 10, we can't start till 10. We need all of you here. So if you are running behind ever, call my chambers and say, stuck on 400, stuck on I-20, whatever the deal is. So we know not to worry. We also know not to send one of Deputy Gordon's friends to your house to come get you. We will take regular breaks. This morning will be a little different. Our first break will be lunch because you had a long break to begin with. But normally there's a morning break, lunch, afternoon break. We also break anytime you need to take a break. It's important that you be focused on what's happening in court, meaning you're listening to testimony. If there's something on the screens, you're looking at what's on the screen. And if you ever find that we've been going too long and you're just losing that focus, just raise your hand. Hey, can we have a break? Get Deputy Gordon's attention, and we'll stop then. But otherwise, it'll be typically those 3 breaks. During the course of the trial, the only people who can interact with you when you are not here in the courtroom is my staff or me. You may be out in the hallway and you see one of the lawyers and you may just want to know where the vending machines are. But if you turn towards the lawyer and say, hey, they're going to act like you've got COVID-26 because they can't interact with you outside the courtroom. You can imagine if you're a lawyer for the other side and you see 3 jurors in an animated discussion with a lawyer for the other side. What are they talking about? I want to know what it is. So they can't interact with you. They're nice folks, but they're not in a position to speak to you unless they're speaking to all 14 of you with me listening in case there's an objection to what's going on. So talk to Deputy Gordon or someone from my staff if you've got questions. We'll end around 5 o'clock. There's not a whistle that goes off at 5 and we all run out. As we approach the 5 o'clock hour, I will ask whatever lawyer who's working with the witness at this time, how much more do you have? And if these lawyers have been giving us credible time estimates and that lawyer says 15 more minutes and it's 10:05, we might go to 5:05 just so we can have a natural break point of, well, we're done with this witness and don't need to bring that person back. But we won't press on till 6 or anything like that unless before you got here, we talked about, could we go late today? And you cleared that with your schedule. If we spill over into Wednesday, I might ask you that because we don't start until a little after lunch on Wednesday. And so when I have those scenarios, because of something I have Wednesday mornings with a different court, I often ask if folks could commit to staying till 6 because we don't start till 12:30, but we'll cross that bridge if we get to it. So let me give you a little bit of the law that you need to be following. I need to give you some basic instructions on some basic principles as well as the flow of the trial. Many of you may have seen some aspect of a trial because you've watched TV. That's not how trials really work. These are dynamic living things and they ebb and flow, and we're going to take unexpected breaks like this morning. And at no point is someone going to walk in here and say, I did it. And we all turn our heads to the back door and that person says, I'm the person who did it. It's not what happens. It's not like TV. First thing I want to tell you about is note taking. You all have notepads and you are free to take notes throughout the trial. You're free to write down the things I say, what witnesses say. I don't want you to try to write down everything because one, you can't. The only person with those skills is Ms. Rivers, who literally is taking down everything. But two, if you bury yourself in your notepad, you are going to miss evidence that's on a screen. Or one of your roles is determining the credibility or believability of witnesses. And if you never look up to see what that witness is doing in response to questions, you may be missing what for you is a tell. Hey, when answering questions from one lawyer, the person was all smiles and looking at us. And the moment the questions got tricky from the other side, there was no eye contact, the person starts sweating, and that might tell you something about that witness's credibility, but you miss it if you're buried in the notes. But you're free to write down what you want. Your notes need to remain private until you begin your deliberations. So if you draw a funny picture of someone, don't share it with your colleagues until you're deliberating. And your notes are a memory refresher. If during deliberations, you individually remember something. The light was green when this happened. Someone says, no, I wrote down that it was red, and they show you their notes, which is fine during deliberations. You can feel persuaded by what was written down, but you shouldn't give someone else's notes precedence if you remember something differently. So use notes as they help you, and know that when the trial is over, your notes will be destroyed. They don't end up as part of the record. So if you're writing down, McBurney is such a windbag, I'll never see that, it will get shredded. You write whatever you feel is appropriate. I am now going to read you the indictment in this case. A reminder, I told you this on Thursday, and it is just as true now. An indictment is not proof of anything. It's the mechanism by which the district attorney's office brings charges against someone. It's a procedural vehicle that brings us all together. And to the charges that I'm about to read to you, Mr. Terry has entered a plea of not guilty, and you'll see that on the indictment. There's his signature, his lawyers, the prosecutors, says not guilty. So it creates the issue that you all are going to decide. The state alleges X. Mr. Terry says, I'm not guilty, and the state has to prove, if it can, his guilt beyond a reasonable doubt. You will get this indictment during your deliberations. You don't need to write down literally everything I write because there's some legalese in there. You'll notice when you're reviewing the indictment back there that there are 4 counts in the indictment and there are 2 defendants in the indictment. This is the trial of Mr. Terry and not his co-defendant, Mr. Adams. There are some counts that apply only to Mr. Adams and not to Mr. Terry. You are to consider evidence against Mr. Terry to see if it proves guilt of Mr. Terry as to the 2 counts that name him in this indictment. I'm going to read you those 2 counts. Mr. Terry is charged in count 1 and in count 3. Count 1 alleges trafficking in methamphetamine. And the allegation is that Mr. Adams and Mr. Terry, and we're focused on Mr. Terry here, did in Fulton County on the 28th of August, 2024, they were unlawfully and knowingly in possession of 200 or more grams of a mixture of methamphetamine, as described in Schedule 2 of the Georgia Controlled Substances Act. That's count 1. Count 2 charges only Mr. Adams. Count 3 charges only Mr. Terry. And the allegation in count 3 is that Mr. Terry, here in Fulton County on that same day, August 28, 2024, did unlawfully possess with the intent to use a scale, an object, for the purpose of packaging methamphetamine. Count 4 charges only Mr. Adams. So you are focused on counts 1 and 3. And to repeat, these charges are just that. They are allegations. They are proof of nothing, and the state has the burden of proving Mr. Terry's guilt beyond a reasonable doubt. Mr. Terry enjoys the presumption of innocence, and it stays with him unless you are convinced beyond a reasonable doubt that there has been proof of his guilt beyond a reasonable doubt to one or both of those charges. This burden of proof stays with the state throughout the trial. We don't reach a point where I say, all right, we've heard enough from the state, now let's hear from the defense. There is not any burden on the defense. I expect that Ms. Wood and Ms. Rios will get up and ask questions of witnesses, just like they ask questions of potential jurors, but they're under no obligation to do so. They've got the right to do so, and they may call witnesses themselves when it's time for the defense case, but there is no burden on the defense. Now, this burden of proof beyond a reasonable doubt does not mean that the state has to prove the defendant's guilt beyond all doubt with some mathematical certainty. It means just what it says. It's a doubt based upon common sense and reason. It's not a vague, arbitrary, or speculative doubt. It's a doubt for which you can give a reason, and that reason arises from your careful consideration of the evidence or lack of evidence. If, after giving careful consideration to all the evidence in this case, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit the defendant. But if no such reasonable doubt exists in your mind as to the defendant's guilt, you would be authorized to convict. The basic structure of a trial is that we start with opening statements. That's an opportunity for the lawyers to give you a forecast or preview of what they think the evidence will be. What the lawyers say is not evidence. So if they get up and say, you're going to hear witnesses say X and Y and Z, and you're writing down, oh my gosh, X happened in this case. That's not the actual evidence. It's not proof of anything, but it's a good roadmap of what to expect. Both sides have an opportunity to give an opening, but neither side has to. When the openings are done, I'll ask Ms. Smith to call the state's first witness. That person will come in, he or she will be sworn in, and then that person's going to answer the very first question. That answer is the first evidence you will have received in the case. Evidence in this case is witness testimony, what they say in response to questions, not the questions themselves, but their answers, and then any physical evidence that's admitted. Maybe the drugs that were seized, if there were drugs seized, or photographs, or a video. That's the evidence that you consider. It's not what the lawyers ask when they're asking questions. Eventually, the state will say, we rest. I'll say, call your next witness. They'll say, the state rests. We will have to take a brief break then because of legal things we need to work through. But then the defendant will have the very same opportunity to call witnesses if he wants to. No burden, no obligation to do so, but an equal right to do so. So after the state rests, I'll turn to Ms. Wood and say, call your first witness. And she may call a witness, but she may not. She may simply say, the state rests. The defense rests, in which case the evidence is closed and it will be what was presented during the state's case. But there may be witnesses called during the defense case, and until the defense rests, we're still receiving evidence. When the evidence is closed, the attorneys get a chance to appear before you again and then make what we call closing arguments or summations. This is when they're going to be arguing to you, trying to persuade you that the evidence proved X or didn't prove X. And you should feel free to be persuaded. They are persuasive lawyers. But remember, what they say is not the evidence. And so if you've got a lawyer telling you, by golly, the evidence was that the light was green, you're thinking, I saw the pictures, the light was red, then that's what the evidence is. You'll be deciding that. But the lawyers will do a very effective job of connecting pieces of evidence to say, here's why you should find the defendant guilty, or here's why the state failed to reach its burden. When the lawyers are done with their closings, I will give you the law, the specific elements of these alleged crimes, and a few other legal principles that you must apply to the evidence as you find it to be. And then you're off to the jury room and you begin your deliberations, where you talk about the evidence and you see if collectively as a group you can come up with a unanimous verdict, whatever that verdict may be. During the trial, the lawyers have a right to object if they believe that the admission of evidence or the answering of a question would violate some rule of evidence. So you may have a lawyer say, objection, hearsay, objection, relevance. I'll give the other side a chance to respond, and then I'll rule on that objection. If I sustain an objection, that means that whatever that question was, the lawyer needs to go in a different direction. That wasn't a legally proper question. If I overrule the objection, then we keep moving in the direction we were going. So I'll tell the witness, you can answer that question. You should draw no conclusions from the fact that I sustain some objections and overrule others. I'm simply trying to apply the law as I understand it to the situation that I arose. And no comment that I make at any point during this trial is meant to be a comment on what I think the strength or weakness of the evidence is, or the credibility of a witness, or the guilt or lack of guilt of the defendant. Every once in a while, in this case, the lawyers may say, Judge, I have a motion. Not an objection, but a motion. That means for you all, probably a bonus break, because a motion is something that they need to talk about outside your presence. We were working through motions this morning while you were getting to know each other in the jury room. I try to cabin those to after you leave or during the lunch break, but as I said, trials are dynamic, and sometimes something comes up and we got to deal with it then and there, and it's more than just an objection. Try to minimize those, but show us some grace, please, if we have to give you an extra break. One other thing I forgot to mention about breaks. When you are on break, you are not confined just to the jury room. You are free to use that hallway if you want to see some sunlight. There actually is sunlight at the end of the hall. If you need to make a call, you don't want to do that in front of everyone else during the break, it's fine to go out in the hallway. Just know that There are 2 judicial chambers in that direction. So if you're going to be yelling at someone on the phone call, don't do it out in the hallway, because then I get a call from my colleague saying your noisy jurors are being disruptive in the hallway. That spoils it for everyone. But you are free to fan out in the hallway. That fridge in there has water in it. That water's for you. You can bring the water out here. You can also bring your own food to put in that fridge. There's a coffee maker and I think a microwave. That's all for you to use in the jury room. I'm going to talk about your role now. We've talked a little bit about what the lawyers will be doing. You will be determining the facts of the case. What happened on August 28th, 2024? And you'll apply the law that I give you to the facts as you find them. In deciding what the evidence is in this case, you will necessarily be deciding the credibility or believability of the witnesses who testify before you. And in determining credibility, you are free to consider all of the facts and circumstances of the case, as well as the manner in which the witness testifies, and the witness's interest or lack of interest in the outcome of the case. You may find, in fulfilling your role as fact finder, that you have a question when a witness is testifying. The lawyers may ask something and you want to follow up on something like that. And there's a way for you to do that. It's not by raising your hand during the witness's testimony, and it's certainly not by just belting out a question. But at the close of every witness's testimony, I'll ask you, if you have questions, to jot them down on those note cards. And you'll see there are 3 stacks of note cards on that shelf in front of a few of the jurors. You should circulate those, and you can be writing them down during testimony. But when we're done, I'll give you a second to write any additional questions that you have down. I'll then meet with the lawyers. We go out in the hallway there. If I think any of the questions merit discussion with the lawyers, because I think maybe there's an issue with the question, in the same way that a lawyer can ask a legally objectionable question, you can too. If your question is objected to, I will not ask it. If it is a legally proper question, I will ask it of the witness. You don't need to put your name or number on the card, just write the question down. And if it's a proper question, I'll make sure that the witness answers that question. The lawyers will get a chance to follow up after your questions, because you often give them good ideas for questions that they hadn't thought to ask. It's important that you keep in mind that you should draw no conclusions from the fact that your question was not asked. All that means is that it was not a legally proper question. It doesn't mean anyone's hiding anything or that there's something about this witness that you shouldn't know about. Questions are not evidence, only answers are. And as potentially non-lawyers, I don't remember all your backgrounds, you may not know that there's certain questions that aren't appropriate. That doesn't mean you shouldn't write them down. Write down the question you've got, and if it's proper, I'll ask it. It's important that you pay close attention throughout the trial. There's not a rewind button, and you will not get transcripts of witness testimony. That's why you can take notes. You will get all the physical evidence. You'll get the indictment and the charge that I gave at the end of the trial you'll have with you. But in terms of what the witnesses are saying, you need to be focused. If you find that you're losing focus, and I already mentioned this, let me know, and we will take a break or get a witness to speak up or whatever needs to happen. It's also important that you view the evidence with an open mind and resist the temptation to make that mind up after the very first witness has testified. That's but one piece of the puzzle that is this case. You don't know what the elements of trafficking in methamphetamine are anyway. And so to conclude after witness 1, I know what this case is about, would be premature. Wait till you've heard all the witnesses testify, heard the arguments of the lawyers at the end of the trial, and then the law that I give you before you start deciding, hey, I figured this case out. You must limit your consideration to evidence that is presented here in court. No outside research. Do not look something up online. That's why I let you ask questions. If someone used a term and you have no idea what that is, write it down. What is, if there is someone testifying about testing that was done on the drugs and they use a scientific term and they don't explain it and you want to know what it is, write it down. Don't look it up. You would be getting information, 1, that may be incorrect, and 2, isn't available for the lawyers to explain to you or to disagree with in case what you found online is only part of the story. No outside research. If you learn that any of your number is engaging in outside research, you need to let me know that. We will likely have to start this trial over. And if you were the outside researcher, I promise you, you will watch that next trial from out there and maybe a few other trials as well, because we will have had to start all over because you couldn't resist the urge to Google something. What you learn about this case has to come from inside this courtroom when everyone is present. That's why you can write down the questions and have them answered. Please don't talk about this case, even amongst yourselves, until you've received all the evidence, you've heard closing arguments, and I've given you the law. you don't start deliberating early. So when you have the afternoon break, it would be inappropriate for you to say, whoa, could you believe, I figured this case out already. You haven't. You may have some strong thoughts about it, but you haven't heard the whole case. So don't talk about it with your colleagues. When you go to lunch, you can eat as a large group or as small groups. You can talk about anything you want other than this case. That also means you shouldn't talk about your experience as a juror with the people close to you in your life, your coworkers, your family, your pets, whatever it is. When you go home tonight and someone says, how was it? One word answer, phenomenal, amazing. Pick your favorable adjective, but don't say, yeah, it's interesting. It's a drug case, because well-meaning friends are going to say, oh, I was a juror once in Kentucky. Let me tell you how it works. And they're going to be wrong. They'll be right about their situation, but they're going to be wrong about your situation. And it's a way to inadvertently get information that you didn't ask to get, but you're not getting from here in court. So you need to be very circumspect between now and the end of the trial. When the trial is over, you can write a book, sing a song, do whatever you want. There's nothing confidential about what we're doing here. You can even talk with other people about your deliberations, should you choose to, but not until we're done with the case and I've received your verdict, whatever your verdict is. Between now and then, you got to be real boring about what was going on here. That concludes my preliminary instructions. My last thing I'm going to tell you is that there are no assigned seats. You should feel free to mix it up. You are going to get a very different perspective on this case than you are, because you're much closer to the witnesses. Some of you may need to be at the leftmost seats, my left, because you need to stretch your legs. You should own those seats. But otherwise, I do encourage you to sit in a different seat each time. No one owns a particular seat. You're going to get a different experience while you're here. With that, I'm going to turn to Ms. Smith and ask Ms. Smith if she plans on giving an opening. Looks like she does.
Yes, sir.